Testing 1, 2.
Good afternoon and welcome to the Appellate Division First Department. You know my shtick. We have 6.5 hours of requested argument time, and I'm sure that your colleagues at the end of the calendar don't want to be here until 8:30 at night. So please ask for the time you actually need, not the time that you want, understanding that this court is fully familiar with your case, the briefs, the record, oftentimes more than you wish we were. So please ask for, again, only that time that you need so that I don't have to cut the time for you, okay? And understand, as I've told all of the panels, the time I give you is what I'm estimating you need. If my colleagues continue to ask questions, I'll let the argument time continue to go. So the better to argue, the longer you get to speak, okay? First case on the calendar, People versus Ronald Burgess. Submit. T. Matthew versus Monica H. Submit. Pepe versus New York City Department of Education. Oh, we're on a roll. Submit. Bulij versus Mileman, and forgive me if I've mangled the name. Okay?
On request 5, Your Honor.
5 and 2 and 5. People versus Eduardo Corona. Submit. Erazo versus Rockaway Village.
On request 5 and 2, Your Honor.
Okay? 5 and 2 and 5. 911 Stanton Street versus Stanton Street Cleaners.
On request 5 and 2, Your Honor.
Okay? 5, 2 and 5. Williams versus New York City Housing Authority.
Request 10 plus 5, Your Honor.
You only requested 10, and so you got to split your request within that 10.
I'm pro se, I wasn't aware that I requested.
That's what I have on my sheet. So let's start with that 10. So how much time would you like to argue and rebut?
8 and 2.
Okay? How many? 5 and 2 and 5, and as I said, if my colleagues keep on asking questions, you can keep talking, okay? All right. People versus Makeda Knight. All right. 4 and 1 and 4. G&Y Maintenance versus McSam Hotel.
Plaintiff did not request, but I request 5 and 2, please.
Okay, when you don't request, I'm going to consider that you are here, and I will let you know in a moment. What else? Stay standing, please. Stay standing. Go ahead. Okay. Okay. 3, 3, and 3. Okay? Board of Managers versus Texas Entertainment. Do you want, where's the appellant? No appellant. Do you wish to submit? Thank you. Landa versus Friedman. Okay. 5 and 1 and 5. People versus Nate Miller. Okay. 6 and 2 and 6. Binmer versus Binmer. 5 minutes? 5 and 5. Minholz versus Columbia University.
Respondent, I just request 3 minutes, Your Honor.
3 minutes. Lamachi versus Elk Manhasset.
Sure, plaintiff respondent, 4 minutes, please.
Okay. All right, let's do 5, 2, 4, and 4. That way we've given equal time on both sides, just about, okay? 5, 2, 4, and 4. People versus Damian Velez is submit. Blue Ribbon versus LBF Travel is submit. First case on the calendar, Boulege versus Mealman. You may proceed.
May it please the court, Jessica Smith for defendants, appellants, the Mealmans. The Mealmans should have been granted summary judgment below. Plaintiff's presence on this area of the property in a remote area of a back driveway was totally unforeseeable.
Well, isn't there an issue of fact with regard to that? Didn't the company say that that your clients were on a call? I'm forgetting the phrase, but that on a as per call. So they would call when they needed to have their gas tank refilled, and then someone would come out and do that.
Plaintiff testified that it was his understanding that it was a will call account, but he did not specifically testify to a call to the Mealmans that to warn that there would be a delivery that morning, and the Mealmans testified that.
Say that again?
So plaintiff testified that it was his understanding that the Mealmans had what's called a will call account,
Right.
which Your Honor was referring to.
Right.
However, the Mealmans testified that the propane company would just come based upon prior monitoring of their usage. And
Right, I got it. There are two different stories with regard to how service is obtained, right? But does that not create an issue of fact? Why
No.
is that not an issue of fact?
Because there's no indication in plaintiff's testimony that the Mealmans were in fact called, and Mr. Mealman testified that he was unaware of a delivery being made that day, and he was never called to be warned of a delivery. So,
But you have it backwards, it seems to me. So if the defendants are saying that this is a will call, right? Then somebody called them to ask them to come over, right?
the plaintiff said it was his understanding. The defendant said it was not a will call account. Suburban Propane would monitor their usage in the first 2 years. This was a long-standing relationship between
Misread this.
the defendants and Suburban Propane. They had been delivering for many years. In the first 2 years, they would.
I thought the defendants said that this was a will call account and that it was the plaintiffs who called them and said, send over some more propane.
No,
That's not what happened.
No, I understand what your Honor's referring to, but that was, plaintiff said it was his understanding. Plaintiff, as a delivery driver, said it was his understanding that there was a will call account that the Mealmans had, but the Mealmans denied this.
Okay, so, right, so we have one side that says one thing, and then we have another side that says something else. So therefore, isn't there an issue of fact? Therefore, because you guys, you defendant, moved for summary judgment, yes?
Yes.
Okay, so your client says that they never called for the propane delivery. Plaintiff says they did call. Why does that not constitute an issue of fact?
Plaintiff did not say there was a specific call. He said it was his understanding it was generally a will call account, but he did not testify that they were called and told that the propane would be delivered that morning.
But I thought that the terms of the will call was that, again, plaintiff stated that they were notified, that his firm was notified to bring the propane that morning.
He merely said that it was his understanding. He did not say specifically that morning.
Okay, so again-
There's no testimony in that regard that he was told specifically that morning and that the Mealmans were called and told that a delivery would be made.
Do we not still have an issue of fact? I mean, what did you, was there anything other than your client's affirmation, I guess, which would dispute those facts? Did you put in anything else other than that's not, we never called?
On the issue of foreseeability, it was the testimony of Mr. Mealman that was submitted in the affidavits of Mr. Mealman, who handles the relationship with Suburban.
Isn't there, your position, I think, was trying to be that, look, temperatures had been warm, there couldn't have been ice. But doesn't the certified weather records that you've put into evidence show that between 2 and 4 a.m. on the morning of the accident, that temperatures had hit freezing?
Yes, so the argument also is that there was no construction notice because temperatures had raised to 42 degrees the day before the accident.
Yeah, but then the day of the accident, many hours before the accident actually happens, right? Because doesn't it happen between, is it 9 and 10 a.m.? Am I recalling correctly? Isn't that the claim? So, but like maybe 7 hours before that, the temperatures had hit freezing. So it's certainly quite possible, if not probable, that there could have been ice in the driveway.
If there was ice in the driveway, it was a result of the refreezing that you had mentioned. What plaintiff's argument
You say it went up to 42 degrees, so that's great for your position, but then when it goes down to freezing hours before.
The argument is that the ice that plaintiff claimed he slipped on could only have been the result of an overnight refreezing, and the defendants would not have had sufficient time to remedy it. These are single-family homeowners. They don't have an employees or staff.
It doesn't take an employee to throw salt on a driveway. I mean, literally, you take your hands in the bag and throw it on the driveway. This does not require hiring a separate person.
This is a 900-foot driveway. The plaintiff fell in a remote.
That's small.
Yes, it's a lengthy driveway.
My point is, there is nothing that would have prevented your clients from throwing salt on the driveway if they requested the delivery of propane through the driveway.
There's no specific testimony that they requested delivery of the propane for that day.
There's an issue of fact on that, right?
No.
No?
That is, as I went into previously, because they were not notified that the plaintiff would be there on that particular day, they had no reason to know that anybody would be in the remote area of their driveway. This is an accessory storage garage. This is not an area in front of their house. This is not the attached garage where they stored their vehicles. This was not.
Are you saying that in order to service this house, someone had to be home, as opposed to there being a pipe with a knob that you turn and affix the hose to?
It wasn't that they had to be home, and said they had to be notified that there was a delivery for that particular day. They had no notice that it.
Anyhow, how do you establish lack of constructive notice as a matter of law if there are freezing conditions 7 hours before?
The freezing conditions were overnight, and it would be an unreasonable expectation to have these single-family homeowners, at however when the
So as a matter of law, we should hold, and this is not an administrative code case, as a matter of law, we should hold that 7 hours is, if it's only 7 hours, as a matter of law, there's no constructive notice.
It's not 7 hours. Plaintiff said between 9 and 10. Plaintiff also
This is between
testified.
2 and 4. Your evidence shows that between 2 and 4, the temperatures were below freezing.
Is it, my understanding of the question is that the single-family homeowners should have been up at 4 a.m. to salt this
But maybe
particular area?
at 8 or 9 in the morning,
Well, plaintiff said he
or 10,
started
if
his.
it happened at 10.
Plaintiff said he started his work at 8 a.m. He arrived at his work facility.
And also, it's not the suggestion is whether we should hold this as a matter of law.
Yes, and plaintiff, well, if I can just get to the testimony about the accident happening between 9 or 10 a.m. Plaintiff actually started his work at 8 a.m. He had 20 stops that day. It took 10 minutes drive between the Mealman's and Suburban Propane's location. So plaintiff's affidavit saying between 9 and 10 a.m. does not match his testimony about when he began his work on the morning of the accident. And there would be insufficient time for these single-family homeowners to address any icy condition that formed overnight before the plaintiff arrived on their property.
Justice Rosado, you had a question? You're good? All right, you'll have time on rebuttal.
Good afternoon, Your Honors. Brian Isaac. I represent the plaintiff respondent. There is clearly a question of fact regarding whether or not there was a call or a non-call situation. The plaintiff had personal knowledge as a driver as to what the account was, and he said it was a call account. The Mealmans absolutely said that it wasn't a call account, but that's a question of fact because it's a summary judgment motion and you're supposed to construe the evidence in a light most favorable to me. If I can, Justice Manzanet and Justice Weber, you were talking, and Justice Friedman, you were talking about spreading salt. I just want to read to you what Mr. Mealman actually said on page 273 of the record. He didn't say he was spreading salt. He said he had a policy of not spreading salt. And let me read you his words. These aren't mine. Quote, I never conducted snow or ice removal by shoveling or using rock salt immediately after a mere freezing rain weather event. Now, that's fine. He can have a policy of not complying with the law, but that's not a defense. That's inculpatory. It's certainly not exculpatory. If I don't want to take continuing legal education courses because I don't think it's beneficial to me and I don't do it, when I get suspended, I don't really think I'm going to have much of an argument to say, well, I can do what I want.
But I think their argument is that this area was not necessarily open to the public or not necessarily open to someone who's coming onto the property. It's in the back or the side or something.
Yeah, so you have three separate areas where they're delivering propane to. One of them is this area. It's not just one, it's three. And Mr. Mealman admitted, let me give you the page if I can, 205, that contractors would use the driveway, make deliveries, including UPS, FedEx, oil, garbage, and other contractors. And where are they going to do it? They're going to do it in a driveway. So I understand that it isn't a business. It's not the appellate division where you have people outside, but it doesn't really take a whole lot to go out and throw out salt, especially, if I can, in a situation where my expert gave detailed testimony as to why this was there for 20 hours. And what he said was, he said there's a difference between air temperature and ground temperature, and that distinction is very important because in the 4 days preceding the accident, the temperature was markedly cold. I would also point out to the court, if you look at 339, line 12, and 349, lines 6 through 7. These are the weather records. It's not my expert. It's not Brian Isaac. I have trouble doing math. This is what the weather people said. Okay, this is in the record. I'm reading it. 339, line 12. Warm air overriding a stationary front along the coast while a shallow Arctic air mass remained entrenched over land led to light freezing rain through the day and also the evening as well as inland. Freezing rain continued even as air temperature warmed above freezing due to very cold ground temperatures. That's
Your expert says it came from the freezing rain on January 18th.
absolutely. That's exactly what he said.
Well, did they put in anything to rebut that? Did they put in other than the weather reports?
No, they had no expert. Their position, as I understand it,
But I think they tried to suggest it was a continuing storm in progress in their reply, right?
yeah, but it obviously
There's no evidence of that.
there's no evidence of that. That's not supported by the
And
record.
didn't the plaintiff say that at the time that he arrived at the location, it was not raining or snowing?
Correct. And it was a solid sheet of ice, which was very, very important with respect to I think their argument is this was completely gone because the weather was it hit 42 degrees at some point, and therefore this wouldn't have happened. So the expert says, well, wait a second, that can't be because the plaintiff testified that the area was a complete sheet of ice. So look, I'm not saying it's a 240-1 labor law case. It isn't. It's not a hit in the rear. But do I lose on summary judgment on this record? I think the trial court got it exactly
In terms
right.
of delivery, their argument was also, because you just mentioned delivery in separate areas, their argument also was that I thought that in order to make the delivery, or the delivery was normally made by the delivery person backing up to the location and then unloading, and so therefore they would not require a delivery person to really have to walk in that area?
But delivery people are going to use whatever they're going to use, and Mealman said it, that they, with different deliveries. The other point I would make relative to that is the case that they rely on is actually Mulholland, which is mine.
Right, yeah.
It's so old, I was a defendant then. Mulholland was a case where the...
You weren't a plaintiff?
I was not a plaintiff. I was a defendant for my father. I think I was 26 years old, and my father had a defense firm. The claim in that case was that a police officer who was injured in a backyard,
Right, yeah.
there should have been removal of snow based upon the fact that there was snow in the driveway. When you read the case, that was a pretty weak case. That's not this case at all.
Thank you.
Thanks for listening to me.
Just briefly addressing the issue of other delivery drivers. This particular delivery was not something that was happening on a recurrent basis. It was also to a remote area. The UPS drivers and the postal workers would not be going to this area, and the postal workers were in fact delivering to the street, and garbage was on predetermined days. To address the issue of the expert stating that the ice existed for 20 hours, well, he fails to take into account the 42-degree temperature.
Well,
Also,
that's the other thing, because the expert states that there's a difference, which in my mind makes sense, that there's a difference between air temperature and ground temperature. So I did not see anything in the record which countered that by any expert testimony or expert affidavit by.
And at what time did the temperature go up to 42 degrees?
that was at 4 p.m. the day before, and it was sustained at
Except the problem is that you have the overnight freeze. And your expert did not contest that there was indeed a drop in temperature under the freezing level overnight, which means that even if, and I assume for purposes of this argument, that it did melt under 42 degrees weather. But once the weather once again dips under freezing, any precipitation on that surface is going to freeze.
Well, just to start with, the first thing is that the expert, we didn't not have an expert, so I just want to make sure there's no ambiguity on that. But plaintiff's expert did not actually cite anything saying what the ground temperatures were. So it's entirely speculative for him to say that the ground temperatures were at freezing, sustaining this ice for 20 hours.
Well, that's not what he said. He said that there's a difference between ground temperature and air temperature, and that you could not necessarily rely upon the fact that the temperature rose to 42, or 43. My point was you never submitted anything to rebut that, to say, oh, well, you know, although yes, the air temperature was 42 or 43, so that means that that any ice or any accumulation would have melted.
There is nothing, an expert-wise, that was submitted to rebut that. But plaintiff's expert opinion was speculative because he did not actually have an adequate foundation to state that these temperatures were below freezing, sustaining the ice. But even if we set that aside, and even if we go to the refreezing issue, still, there was not a sufficient time, even if it was at 8 a.m. at 9, for these single-family homeowners to go out to this remote area of the driveway where they had no reason to suspect anyone would be, in order to, be deemed as having constructive notice as a matter of law.
Thank you. Arazo versus Rockaway Village.
Good afternoon again, Your Honors. I'm still Brian Isaac, but I represent the appellant on this one instead of respondent. I think the easiest way for me to do this is if you could look at 804 to 805 of the record, that's the blown-up photograph. I can't conceive of how that isn't a 240 violation. I'm sorry. That's a blown-up photograph of what they were standing on. So this poor guy who never, ever actually did the concrete mix is being asked to stand on a 1-inch piece of rebar with no protection at all, holding a hose that is so heavy that 5 or 6 other individuals have to cover it. One of the witnesses that the defendants talk about, the signed statement, actually says, if you look at the statement, that other people had fallen before in this situation. There's no protection of any type.
Mr. Isaac, on this record,
Yes.
and given the pictures I've seen here and the nature of how this concrete is poured or placed, as they claim in the industry, among the safety devices you claim that should have been provided is plywood, which, based on the custom and practice as I see here, are just not workable. And I just don't see, and the notion is that everyone was walking on this rebar on the deck. This is what they do. Putting aside other inconsistencies.
Sure.
So how do you deal with that?
Well, let me deal with it, and let me try to convince you, if I can, Judge Schulman, in 2 ways. First, custom and practice is not a defense. And if you read my adversary's brief, it's beautifully written.
Yeah, but let's take, I want to piggyback on what my colleague has said, because the pressure from a cement hose pouring concrete is very, very forceful. And it seems to me that if you have an unsecured piece of plywood sitting on top of rebar, and you shoot off the concrete in this hose, this guy's gonna go airborne. And that plywood could become a rocket in that space and potentially cause even more harm to the workers. So explain to me why
I understand the
it's like a
concern.
skateboard on.
So if you look at 805, I'll try to explain it because I knew I was going to get that question. The plaintiff, as you know, said on 207, and then said in his affidavit, that the pour wasn't exactly where he was. It was 35 to 40 feet away. I'm not suggesting to you that it's not potentially problematic to stand on it, but all you have to do, because remember, the defendant's position is he never had to lift it up, right? They have 4 or 5 affidavits saying you're supposed to pull it. I think if you pull it, you have to kind of stand up. But all you have to do is actually put the pour where you're going to pour it, wherever it is, because it's a giant area, let the person stand on it, and then just move away. I'm not suggesting to you that he has to stay right here. If he's pouring the concrete here and he's standing on a hose, he could get hurt. But if you look at the photographs, they don't have to do that. They could actually put the hose there, delay shooting the concrete out, move back, and he's not in any danger whatsoever.
Wasn't there inconsistencies, though, in what he said? I mean, didn't, in the deposition, he said he was, or in the affidavit, he said I'm confusing the 2 points. One is he's 35 feet away, and in another point, he's right there. So he doesn't even have his story straight here.
I would suggest to you that that's not correct. Let me give you the record pages if I can. I have them. Okay, so on 207, line 20, I'll read it. Question, were they pouring the concrete across the entire floor that you were working on the day of the accident? Answer, no, only on one side. Question, had any of the concrete on that floor been poured at all on that day of the accident before your accident occurred? No. Now, my adversary is going to point to 276 to 279. And I think that's what
where he says he was right next to where it was being poured.
correct. Except I think that the problem is that if you look at the testimony, the term rebar that's used on 279 line 6 isn't meant to be that rebar. He's referring to the entire,
Go ahead.
may I? I'm sorry. I always ask permission. He's referring to the entire rebar structure. And you have to read not just from 276, you have to start at 276 line 14 and go all the way to 279 line 10.
So even if I accept what you've just posited,
Yes.
why is that not an issue of fact?
Because I
Right? Because from our reading, we're not clear whether he means the rebar right here by his feet near him or the rebar 20, 30 feet out, right? And in my mind, it makes a difference because if you're shooting rebar straight close to you, that's going to have presumably a harder pushback on your body from the force of the stream of the concrete, which is heavy.
I'm not denying it. Look, I said it took 6 people. I know what I know what it does. My only point is that when you look at the affidavits, right, it's the old Sherlock Holmes story. Sometimes what isn't said is more important than is what's said, right? You have 6 people who were there. All of those people knew what was going on. None of them submitted an affidavit except for the affirmed statement, which supports my position that they were falling. And you have the supervisor, Mr. Chapin. They don't get his affidavit either. They just get affidavits from people talking about general custom. I don't think Zimmer allows that. Yes, there's no question that Salazar says that if the work that you're doing would be inconsistent with the protection you propose, you can't win. But Salazar was a different case. You know that.
Right.
He put concrete on the ground. He was pushing it back, and there was a hole that he was going to cover. You can't cover that. This can be covered. And to put him in that situation where he has no protection whatsoever, remember, Zimmer, they said, we can't do it. It's not practical. It's not proper. It can't be done. And I think if you look at the defendant's expert's testimony and look at Mr. DiDonato's testimony, who's the superstar, they don't use the word impossible. They use the word impractical. That's not consistent with Zimmer. And as 2 of the judges on this panel know, 2 weeks ago, the Brian Isaac case, which is I argued, even though it's my name, it specifically says that that's not a defense. So I'd ask you to take a look at that.
Thank you. All right.
Good afternoon, Your Honors.
In anticipation, you're going to need extra time like him. I'm giving you an extra minute. Go ahead.
Matthew Bremner, Harrington, Occo, and Monk for respondents, defendants. To start off, this is not a falling object case, Your Honors, under Labor Law 240. The hose that was...
Whether it is or it isn't at the end, there's certainly an issue of fact about whether the hose was lifted or whether it was being pulled along. I understand, as Mr. Isaac has set forth, there's some evidence supporting the view that it was lifted, but then you have DiDonato, you have Zapata, who certainly make it seem like it was dragged along.
Yes, Your Honor, I do realize that plaintiff offers a conflicting account. We are responding, and our position is that the lower court's decision, which found tribal issues of fact, should be affirmed as is. We're not affirmatively moving for summary judgment under 240. So, as Your Honor, you astutely pointed out, there are 5 defense witnesses who all contradict plaintiff's version of the accident.
Were any of those 5 witnesses any of the men who were actually on the floor pouring the concrete?
Mr. Zapata was, Your Honor.
Okay.
Mr. Zapata was plaintiff's coworker, and he describes in detail in his affidavit the process for pulling the hose, and it's very clear from his affidavit that...
Does he affirmatively say that on that day that's what they were doing?
Yes, he says that the hose was being pulled, that all 6 of them were working together, that a signal would be given, and that all workers in unison were to pull the hose to drag it along the rebar. However, plaintiff missed one of those cues, and apparently the hose was dragged onto his foot, pinning him between the rebar and the hose.
Sir, wasn't this his first foray with this hose?
According to his testimony, it was, Your Honor, but it was clearly within his...
Did anybody controvert that? I thought in the record he had another job and was asked to help with this particular...
I think that is uncontroverted, Your Honor. That
He had been working on the columns, right?
Yes, but on this particular day, he was involved with the concrete pumping operations with respect to positioning this hose.
Did the columns involve concrete?
The columns, that is different work from the specific work of pumping the concrete in the rebar cage.
I thought his job on the columns was to do the actual rebar, to tie them, twist them, connect them for the purposes of all of the columns, the pillars that hold up the floor above.
Yes, Your Honor, but just because that was a task he had been previously assigned does not mean that he could not be delegated to help with
That's
concrete
not what
pumping
I'm saying, but look, there's a difference between twisting rebar and the experience that comes with handling a hose with very high pressure of a very heavy substance. Those are two totally different things,
I
right?
agree with your
Okay.
point 100%, Your Honor. I would just say that I don't think it's relevant to the Labor Law 240 analysis in this particular.
Well, it would be relevant if he has had no experience, no training, and no supervision on how to handle a hose. Wouldn't that be important?
I think that would be important to plaintiff's Labor Law 200 claim, which is still preserved, and he can still make those arguments. But I think the operative question under 240 is whether there's an elevation-related risk and whether he was provided adequate protection. We're saying this doesn't even rise to the level of an elevation-related risk. He was dragging a hose. Another thing is that plaintiff's expert cites various safety devices that he said should have been employed to secure the hose. But if you actually look at what those devices are,
Well, for example, the Dragon Head device is thousands of pounds. It would have destroyed the whole rebar, right?
yes, Your Honor, but I think even more crucially, he talks about the possibility of using ropes, cables, chokers, safety slings, sleds, or a line dragging. All 6 of those devices,
said
the
they're
purpose of it is to drag the hose.
Right, and you also said there would create a tripping hazard or something of that nature. Back to Zapata, though, did he not also state, however, that during this process, many times the workers would fall?
He did.
So does that lend some credence to the argument that perhaps there is a better way or to do this?
I think it lends, may potentially support the plaintiff's argument under Labor Law 200, which would deal with the means and methods of the work and whether it's safe. However, that deals with issues of supervision, direction, and control, whether Latier or the owners, who are the defendant's respondents, had that exercise, direction and control over the work. And those are issues that are not before the court on this particular motion, Your Honor.
Continue.
Then turning to plaintiff's theory under whether plaintiff was a falling worker, the lower court issued a very terse decision, but it astutely picked up on the similarities between Salazar and this case, because Salazar is really controlling in this case. In Salazar, the plaintiff was a concrete worker who's similarly involved with concrete pumping operations and stepped into a trench that was located where the concrete was to be poured. This case is indistinguishable.
Except that in Salazar, he was a concrete worker. Here, this worker is not a concrete worker. He's a rebar column worker who was pulled off his regular assignment to do something else that was not in his wheelhouse.
Your Honor, I would say both of those fall under the category of concrete work for the subcontractor that was performing the work.
What evidence in the record is there to support what you just said?
RC Structures is a concrete subcontractor.
What? Where in the record does it say that a concrete rebar worker is the same as a concrete pourer?
It does not say that in the record.
Oh, okay, I thought that's what you just said. So I was confused.
With respect to plaintiff's testimony, I think 278 and 279 of the record are really instructive. Question, at the time the accident occurred, was concrete being poured through the hose? Answer, yes. And was the concrete being poured onto the rebar you were standing on? Answer, yes. Finally, Your Honors, Brown, which is cited by plaintiff's counsel.
You have a red light, so I'm going to give you 20 more seconds. Go ahead. To finish your
Thank you, Your
thought.
Honor. Brown is distinguishable in this case because in that case, there were no ongoing concrete pumping operations going on. Plaintiff in that case was a carpenter who was walking over a rebar column to deliver materials to another area of the site. And accordingly, Brown is totally distinguishable. Respectfully, We ask the court to affirm the lower court's decision in this case. Thank you, Your Honors.
So, Your Honor, I didn't love my answer to your questions before. Let me try to improve on them a little bit. And here's what I want you to consider. If, in fact, as you've suggested, this is an especially dangerous situation that can cause serious problems, under 240 sub 1 of the labor law, shouldn't it be protected against? Just don't throw up your hands and say nothing.
Yeah, the question is, how? Right? So if you've got, when you are pouring a concrete slab floor, what was described in the record is what is done on every single job. You create these grids of rebar, and then you have a pour over the little squares until you have a full floor, right? That's the way you do it. And I would imagine that the higher up on the floors you go, the harder it is to access equipment that makes it safer. So at some point, the industry has to figure out what is the safest way, right?
That's true, except with the labor law, we know going back to Zimmer, Koenig, and Quigley, Quigley's 150 years old, that it isn't the industry that sets the standard, it's the courts that set the standard. Because the fact of the matter is that the courts have held out.
So tell me, what do I have in this record to set a standard for how to safely pour concrete in this industry that would not slow down the industry to a snail's pace?
So I think what you have is you don't have any affirmative statements by them with respect to my prima facie showing saying that it was improper or not doable. Let me read to you what their experts said. 761, paragraph 15, line 4. The securement of covers and or walkway material to the rebar was impractical, not impossible, not couldn't be done, due to the progressive nature of the concrete placement into and filling of formwork across the floor, roof, or horizontal CIP slab.
I see that as semantics, impractical as opposed to impossible. I don't see the emphasis that you're placing on impractical versus impossible.
Well, I think I'm trying to take it out of Zimmer. I mean, if you have that problem, I have a problem. But I think that Zimmer, when you read the Zimmer case, which we all know, they said, look, we just can't do it. It's just not a practical way to do
What
it.
specifically, to get back to Judge Manzanet's question, what specifically should they have done on this job which they didn't do?
What I say they should have done is they should have placed plywood on.
Right, but Judge Manzanet mentioned you'd have a flying carpet.
We're gonna have construction workers with plywood going through their eye,
Judge,
okay? I'm serious now.
No, I got it. That's not what I'm saying.
And the ropes, it's a tripping hazard. You can't have additional equipment or ropes or ties or whatever on the
I'm suggesting that you don't have to, you shouldn't, I understand the flying worker situation. What I'm saying is.
I'm worried about the flying board, okay? I mean, if even a little bit of that concrete air and pressure hits that board is it's kind of like being in an MRI room and you have metal. That sucker goes airborne. That's what will happen with a piece of plywood that gets hit by the pressure of a cement hose.
My suggestion isn't that you're not right. I understand you're right. What I'm saying is the worker doesn't have to be holding on to this and be in an area where the concrete is. If you look at 804 to 805 and you look at 612 to 617, the photos, there's tons of rebar. So all they have to do is walk it over and then get the person away from it so he's not standing there while he's actually holding the concrete. That's just dangerous.
Got it.
Thanks for listening.
Thank you. 911 Stanton versus Stanton Street Cleaners. You may proceed.
Good afternoon. May it please the court, Andrew Cassidy of Cougar Marino, Winiarski, and Bittens for Appellant 911 Stanton Street Realty Corp. This appeal results from an award of partial summary judgment granted in favor of appellant which awarded as against tenant all rent due under the lease, that's both rent arrears and accelerated rent, but failed to award appellant attorney's fees as against tenant and failed to award appellant summary judgment as against guarantor. It's clear reversible error, and the Supreme Court's order should be reversed and or modified to grant appellant summary judgment as against guarantor and judgment for attorney's fees as against tenant. With respect to attorney's fees,
Well, you're the prevailing party based on what you described, correct?
that's correct,
Then
absolutely.
it should be a slam dunk.
That's absolutely correct. The lease provides that the prevailing party is awarded attorney's fees upon appellant being awarded summary judgment as against the tenant. That provision triggered, and the appellant should have been awarded judgment as to liability for attorney's fees as against tenant. Moving on to the issue of guarantor liability. There's a personal guarantee between the parties, and that personal guarantee renders the guarantor liable for all of tenant's debts. And here, as stated previously, appellant was awarded summary judgment as against tenant for all rent due under the lease. That would be then tenant's.
Explain to me why the good guy provision is not applicable here.
So the guarantee provides, and the guarantee, the language thereof should be strictly interpreted and construed. It provides that a surrender would limit the guarantor's liability if it's effectuated under the terms of the guarantee, which requires a written declaration of intent to surrender being delivered to the landlord, at which point then at the end of the month.
Everything that was done was done, and in addition, they had sent a written notice to the landlord, we're getting out, the guarantor would be out?
Assuming the tenant had done what the guarantee provides. The guarantor would be.
So, are we right that there were 3 conditions in order for the guarantor to be free of liability, right? Am I correct that you are arguing that they failed to meet one of those provisions, that being the notice?
That is correct.
Okay,
Guarantees.
Right, so what was the manner in which their surrender was communicated to your client?
On October 19th, 2020, tenant handed the keys to the landlord.
There was
That was the surrender.
no email, no text, no other communication?
There is.
That I'm coming to bring you the keys because COVID is killing our business, we're out.
There is nothing in the record supporting any sort of advance notice to the landlord by the tenant as any intent to surrender. The keys were dropped off. Now, importantly, returning to Justice Friedman's question.
Was there any email after the fact, after giving the key, confirming that they had turned over the key, they have vacated the premises, and considered themselves free of the tenancy?
Again, there's nothing in the record supporting that, and no allegation made by tenant or guarantor in the lower action, indicating anything of that nature.
Okay, got it.
I do just very quickly want to return to Justice Friedman's point as to had the tenant done everything that was required by the guarantee, that would only limit guarantor's liability for the accelerated rent after October 19th, 2020. The rent arrears, guarantor would still be liable for, and so even if there is a question of fact as to the surrender, which the record does not support, the surrender was not effectuated properly, the guarantor would still be liable for all rent that had accrued through the date of the purported surrender.
Okay,
And I see that I'm running low on time. Are there further questions? If not, I'll.
thank you. Just under the wire, you had 30 seconds left. You may proceed, sir.
Good afternoon, Your Honor. Nirav Shah of counsel to Trinity Law Group. Your Honor, our position is that the lower court correctly decided there's an issue of fact as to the liability of the guarantor. There are many issues.
So the lease was very clear in terms of how the guarantor could limit their liability. And it set out 3 conditions that had to be met in order for the guarantor to avail himself of that release. Were those 3 conditions met?
Those conditions were not met. They could not meet those conditions because there are certain issues that prevented them from, one, paying the rent. One, there's
Well,
issues.
I'm focused on the condition of giving a notice. Explain to me why the guarantor could not simply send an email, a letter, a text, any writing, because this court has said any way that you write it is okay, right? But you must write it. So what possible explanation could there be for the guarantor having failed to send a writing declaring?
Well, he handed the keys to and dropped them off at the landlord.
But the lease was very clear that you had to declare it in a written notice. So how does this court, even if we have empathy, how does this court get past that writing?
Well, I think part of the issue is also the discovery and depositions have not been completed.
Yeah, so you want discovery, so, I mean, you're not answering the question. But, I mean, are you suggesting somehow that because the landlord accepted the keys, that constituted a acknowledgement of surrender?
Under operation of law, there's certain circumstances, if it was not done in writing, the actions taken by the tenant and the
So
landlord.
the answer is yes. You're suggesting that because the landlord accepted the keys, that constituted a surrender of the premises?
That can be constituted.
And that's based on what case or what provision in this lease agreement?
Not in the lease agreement. I cited some case law as to there's issues of fact as to whether by operation of law, there is an actual surrender based on the acts taken by the tenant. Based on the
What case says that where writing requires written notice, clearly, unambiguously, that surrender of the key by itself would suffice? What case says that?
I do not have a case that says that.
Because there is no case that
Because
says that.
that's not what the law is. But let's get back to the discovery. You're requesting discovery. What exactly is the discovery that you are requesting? What discovery would be needed from the landlord? And how would that go to your claims as to surrender?
Well, all communications, all text messages, emails, all that information, the deposition also as to what their understanding was at the time when they
But
accepted the
any
keys.
emails, text messages, certainly emails and text messages, if your client was one of the parties to that communication, you have that. So you don't need discovery to know what the emails and texts were between your client and the other side.
Well, we still don't know, well, if my client doesn't have all information, he doesn't have copies of everything that he maintained, that's why we requested copies of everything that the landlord has, their complete file on this. Because my client wouldn't, he certainly you're right, he may have that information, but he searches records, he doesn't have all the communications, all the emails, all the conversations he had with the
So are you suggesting that there's some email wherein the landlord stated, oh yeah, just give me the keys back and that constitutes a
possibly,
surrender?
yes, because
Possibly.
because he
possibly. Does possibly mean like speculation?
well, because he did meet the landlord there, so he did meet the landlord understood, oh, you're giving me the keys, so
That kind of goes back to the point that turning in the keys does not constitute surrender under a lease agreement that specifically requires written surrender, written statement of surrender of the premises. It's kind of circular. At least, the way I'm reading the papers, I could be mistaken.
yeah,
Doubtful, but, it's always possible that I'm wrong.
just going through my other points, also the lower court, when they made the decision, they claimed issues of fact as to, how much is owed by the guest.
And that's why we're here to decide whether that's correct or not.
Okay.
Thank you so much. Counsel, you have 2 minutes.
Thank you, Your Honor. Very briefly.
I don't think you need them, but go ahead.
Briefly on rebuttal. With respect to the concept of surrender by operation of law and related discovery, first, as a matter of law, the case law provides that a surrender by operation of law may occur where the landlord acts in a way that is so antithetical to wishing to keep the tenant on the hook for the rent.
How long did it take for your client to file suit?
It was from October 2020 to February 2021. So that for surrender by operation of law, there'd be some sort of reletting or just case law that has the landlord re-entering the premises and removing the tenant's things and putting a for rent sign out front, or just fully reletting and having another tenant move in. That did not occur. There's no facts in the record supporting that sort of contention. Second, neither the tenant nor the guarantor here pleaded surrender by operation of law in their answer. They only pleaded express surrender under the terms of the guarantee, which, as we previously discussed, did not occur. And third, it was a motion for summary judgment where tenant and guarantor had the opportunity to lay bare their proof after the landlord, the appellant, made a prima facie showing that no surrender had occurred and that the guarantee had been violated, or no surrender had occurred under the terms of the guarantee. And if there was objects somewhere in discovery that tenant or guarantor wished to have obtained in discovery, those would be notices that the tenant or guarantor had sent to the landlord, which one would assume would have been produced in opposition to summary judgment and would be part of the record. But here there is no such facts in the record. Landlord made a prima facie showing and tenant failed to rebut that prima facie showing. And finally, just very briefly, to the
Counsel,
extent—
you got 5 seconds.
frustration of purpose with respect to COVID-19 is insufficient as a matter of law, and therefore
Thank
there's
you
no issues.
so much. Have a good evening. Williams versus New York City Housing Authority. All right, you can come up to the podium
Thank you.
and you may proceed.
Good afternoon, Your Honors. Thank you for this opportunity. I am not an attorney, but I am a 55-year-old resident of Throgs Neck Houses. I'm fighting cancer now, and I stand
I'm
here
so
in front of
sorry
you-
about that.
Thank you. I stand here in front of you represented and supported by thousands of residents who won't get this opportunity, as well as the politicians and leaders and judges who have supported me in this third-party documentation that has yet to be on record in 10 years due to New York City Housing Authority's retaliation. I stand here and my argument is about whether Judge Bluth regurgitated New York City Housing Authority's language and did not hold the 2019 explosion being on channel 2, 4, 5, 7, 9, 12, and all the mayors, governors, and cities who said New York City Housing Authority devalued Black, brown, and yellow residents in Throgs Neck houses. And why that it's important that Judge Bluth take that into consideration, because in my third-party documentation is the evidence that I'm a former NYCHA employee best of the best. I worked in my development for those years and was handpicked by the president to work for the 250 Broadway office.
I hesitate to stop you, but I want you to understand that we, under Article 78, this court has very limited jurisdiction. So we have to decide, because I want you to center your arguments on what we have to decide, right? It's not that I don't want to hear you, okay? But we have to decide whether the court that rendered the decision on the propriety of the Article 78 decision was appropriate, whether the court properly found that the decision which was entered on default should have been vacated or not. So that is the only issue that we can decide, right? So I can hear your argument and perhaps think, wow, there's other stuff going on here that's valid. Unfortunately, I am bound to only consider
The Article
this
78.
last Article 78. That's the only thing that me and my colleagues can decide.
Well, thank you for the
Okay.
direction, Your Honor. I appreciate that. Well, according to the Article 78, my documentation that I put into Judge Bluth specifically stated I did not receive the documentation from New York City Housing Authority. They had a responsibility during that COVID period to make sure that this very serious document, which was put in, first of all,
Meaning the notice to the hearing.
Exactly.
Okay.
The notice to the hearing and the documentation that was put in for the hearing.
Okay.
And the third-party documents. Also, too, they did not send anything, FedEx, UPS, DHL, for the importance to make sure that I would receive that documentation of their answer from the 3 to 4 person panel, which
And we're
I
talking
requested.
we're talking about the proceedings which occurred in July 2019. That's we're talking about the termination proceeding.
That's correct.
Okay, so did not your attorney at the time notify you or tell you of the proceeding? Because according to the record, if I'm not mistaken, that your attorney had contacted you and told you that there was a proceeding that day and that you had stated, he had called you numerous times, placed multiple phone calls to you concerning the termination hearing.
In truth, Your Honor, that is not the truth. My attorney was let go 2 weeks prior in a decision in order that not only New York City Housing Authority had, but I also had. It's a decision in order from the lower courts on 160.
No, but the issue is, because that's fine, a litigant always has the right to say, you're not my lawyer anymore. So
No,
I'm good with that, right?
If I may explain, Your Honor, he asked to be discharged.
Okay,
He was going through an Alzheimer's episode in the court. He asked to be discharged after
Okay.
3 years of dedication. When he asked to be discharged, New York City Housing Authority didn't have an issue. This is 2 weeks before the day that was in question. They received a copy of the decision that he was discharged as my attorney. The reason the Honorable J. Stewart Dankford showed up is because he keeps a black book because of the Alzheimer's. And what happened is he showed up and he forgot because of Alzheimer's, which is in my third-party documentation evidence that I handed in, that he had a miscommunication. And he states in his writing he had a miscommunication with his client. On the day in question, I was deathly ill. And he was ill prior to that. This was the winter vortex.
Well, that's the other thing, because apparently the documentation that you submitted concerning the fact that you were ill
Yes, Your Honor.
did not cover the period or the time of the hearing.
Actually, Your Honor, that's very callous on New York City Housing Authority. If I have cancer and I have a letter saying that I'm dying on Monday, they're going to say, oh, well, you wasn't dying on Friday. But what I said to New York City Housing Authority is, you have had record that I'm dying of cancer. You have had record that I don't have an attorney anymore. As a disabled person, I have rights to have another attorney because the lower courts at 161st Street, if you look at the decision in order, they put it for January 21st. So if the lower courts, once he was discharged, put it for January 21st, and please, Your Honors, keep in mind, New York City Housing Authority already broke policy and procedure and had me in 2 proceedings at the same time, eviction and a termination of lease. That doesn't happen except in retaliation. So they were stretching me thin, a sick man, stretching me thin in 2 different places at the same time. Working for New York City Housing Authority for the president, I know that you're supposed to have the termination of lease first and then go through with the eviction. But they broke the policies and stretched it. And they make you believe through their writing that somehow I just didn't show up for a hearing. 2 years had gone by.
I think it was more than not showing up for the hearing. It was also the fact that you were in arrears. That was the whole point, right?
Your Honor, I was not in arrears. This is a fraud case created by New York City Housing Authority. In my third-party documentation, I handed in, I have abided by every agreement. I have lived in 1 apartment for 55 years, 0 probationary period.
So the fact that they have that their records show that you're in arrears for $86,000 and that you had not paid rent since, I forgot what year, but that you were in arrears for $86,000, that is incorrect?
That is just one part of their retaliation, Your Honor, and my document proves the years and the history of this case. I brought New York City Housing Authority Court when I was a teacher for the Department of Education for years. I won a landmark case in 2007 by the Honorable Judge Jaya Mudhaven, who found NYCHA guilty of willful neglect. That's a landmark case. I'm the only person in the Bronx who won that landmark case and found them guilty of willful neglect in 2007. It would take 12 years for the 2019 blowout revelation to happen on television. We would have to suffer. Black, brown, and yellow people would have to suffer at the retaliation. It's already been proven that they're guilty of devaluing
So the retaliation
our lives.
is based upon the fact that you won this landmark case?
It's based on the fact that I'm a former New York City housing employee, the best of the best to the president. He took me from Throgs Neck Houses out of a whole staff in one summer session, and I was promoted to the 250 Broadway office as his receptionist. I was exceptional 30 years ago.
All right, you'll have some time on rebuttal, okay?
Yes, Your Honor.
Good afternoon, Your Honors. Seth Kramer for Respondent, New York City Housing Authority. In terms of the failure to appear at the hearing and the health issues at that time, page 77 of the response appendix is the transcript from the hearing that occurred in December of 2017, just 1 month before the default. And Mr. Williams was there on that day. And in the submissions to attempt to vacate the default, he went into details about the health issues of his former attorney, but not for himself. He submits documentation from health issues various
So
other times.
that date, the December date, now that's when it's put over to January, to another date for the actual hearing?
Correct, Your Honor.
So on that first date, does the court make all the parties aware of the adjourned date, the date for the hearing?
It would have happened. I'm not sure if it's in the record. But
And then then the discharge of the attorney occurs on that date or prior to the hearing date?
what petitioner's referring to is in a separate housing court proceeding, I think shortly before the January hearing date. Mr. Denkberg was discharged due to health issues. And then he appears on the hearing date and says, I can't represent him anymore. I was discharged, but I'm here anyway. I told him to appear.
And on that date, is that when the court was, well, according to the record and according to the findings by the court, that's when the court was told that Mr. Dankberg had notified Mr. Williams of the date?
Correct, Your Honor. It's in January 2018.
Would you address, appellant says, Mr. Williams says that there aren't arrearages. What's the situation with that?
Well, there's never been any claim that he's made any of these payments. Since 2011, there have been, I think I said in my papers, 3 payments. I saw one other going through the rent ledger again in preparation. So it's 4 payments totaling about $1,100.
Wasn't there another issue of income eligibility?
It's not income eligibility. There's a separate issue from the chronic rent delinquency dealing with failure to submit the annual recertification documents.
And that affects one's ability to be able to stay in the apartment.
Yes. Since it's an obligation under a lease, and since 2011, none of those recertification documents have been submitted, so the Housing Authority have been unable to verify the income along with the household composition.
Is it your position since 2011 he's paid 4 months' rent?
I'm sorry?
Is it your position that since 2011 he's paid 4 months' rent? Is that what you?
It's not 4 months' rent, made 4 payments.
So what are
Totaling
the
$1,100.
arrearages?
Totaling $1,100, correct.
What are the 4 payments came to $1,100?
It added up to $1,100, yes.
And how much are the arrearages according to Nigel?
The total arrears as of the time of my motion to the lower court was $111,000.
What about Mr. Williams' statement that you're pursuing both an eviction as well as a termination?
Yeah.
So what we're not permitted to do is pursue a holdover proceeding in housing court based on a terminated tenancy without having first gone through the administrative hearing process. The housing court proceeding that was going on at the same time as the administrative hearing wasn't a holdover proceeding.
The non-payment?
It was a non-payment proceeding. A non-payment proceeding is brought against an active tenant based on non-payment of rent. Standards are somewhat different.
So on the December date, his counsel is relieved as counsel due to his own illness. Typically, there's an automatic stay that's placed into effect to permit a litigant time to obtain new counsel. Was that observed here?
I'm not sure whether that is relevant at the administrative hearing stage as opposed to in court proceedings.
This is a very simple question. I have never seen, ever, the relief of counsel without the concomitant stay unless the litigant has an attorney present in court who's ready to take charge. So, again, was there a stay granted to this man when his attorney said, I am no longer mentally fit to represent him because of my own illness? Did he receive the stay he was entitled to get time to obtain new counsel for his next date in January? Did he get that?
This was in January. He wasn't relieved of counsel. He was relieved of counsel at the housing court proceeding. In terms of the
Are
administrative
we going to
hearing-
play semantics here?
I'm
Because if
just
he got off
clarifying.
one case and he's not capable of representing him on one, then he's incapable of representing him on everything.
It's different
So
attorney.
the question is, was there a stay issued permitting this man to get counsel to represent him? Whether he's right or wrong, he's entitled to counsel.
You're not,
And certainly entitled to time to get counsel where an attorney is sick and can no longer represent him. Did he get that?
the hearing officer issued the inquest decision when he did not appear in January. Did not
So the
automatically
answer
adj-
is no?
Did not automatically adjourn the administrative hearing at that
So
point.
the answer is no.
So the answer is no. There was
So
no
he was
automatic
without,
adjournment.
so in other words, he was without counsel at the time that he was found to be in default.
He did not appear on that day, and the counsel that did appear came and said, I am not representing him in this proceeding anymore. I told him to appear.
So he was without counsel.
So he was without counsel. Now, obviously, you're
Your
not-
position is that since he didn't appear, therefore, no counsel could have been assigned, or the matter could not have been adjourned for purposes of counsel, because although counsel appeared and was relieved, he did not appear.
Correct, Your Honor. And regardless, the standard for vacating a default is both the meritorious defense and the reasonable excuse. And just separately,
Can someone assert a meritorious defense without counsel?
yes, Your Honor. Pro se people have done it all the time, and I've seen many applications granted over the years based on that. That's to lift the default, though. The meritorious defense. I'm not talking about at the actual administrative hearing. Subsequently, when
Well, a default should not have been entered if he didn't have counsel, presumably, or at least arguably.
I guess
Right.
arguably. One separate issue I just want to raise quickly.
Counsel, you're out of time, so I'm going to give you another 30 seconds.
Thank you. The actual underlying motion was a motion to vacate the stay, because the stay was conditioned and was premised on the idea that petitioner had not submitted his application to reopen his default. The hearing officer hadn't issued a decision on that. So separate and apart from the merits of the hearing officer's decision, there's the issue of the stay where no payments had been made for years and years, and the conditions required from the court, the application hearing officer's decision took place. Thank you, Your Honor.
Thank you.
Honorable judges, New York City Housing Authority is lying to you. The same way they lied to you about 2 decades of making repairs and taking millions of dollars for the government and not doing it. I have never chosen not to pay rent. There's judges who ordered them to fix the apartment for years. That's a history that proves that they denied me services. There are judges who willed in my
But I'm
behalf
not
and find them
understanding, what's the
guilty.
relevance of NYCHA not making repairs if in fact you've paid rent?
The relevance is-
Normally,
the
when
re-
someone argues that repairs are not being made, that is a rationale or basis for not paying rent. And we know that NYCHA is notorious for not making repairs. And we're well aware of the conditions of the NYCHA housing. I mean, I think we all know this, and I think NYCHA will admit to this. So I'm not really understanding
The relevance-
why is it relevant since you claim that you made payments,
Honorable Judge.
since you claim that you've made payments, rent payments from 2011 on. How is it relevant that no repairs were made?
Honorable Judge, I didn't say I made payments. I said I put into evidence documentation from New York City Housing Authority that stopped the payments. If they have an
I'm
issue-
sorry, repeat that.
New York City Housing
yeah.
Authority.
I'm sorry, did you escrow all that money?
No, New York City Housing, what was happening, Your Honor, is New York City Housing Authority, this retaliation does matter.
New York, continue your thought. New York City Housing
New York
Authority.
City Housing Authority was putting through retaliations. They were
No. Let's get to the payments.
New York City Housing Authority made a document to stop me from talking about the rapes and the
No.
They
I'm
told me
trying.
not
I'm
to
trying
pay
to
rent.
focus. I'm so sorry, but I'm tired. I'm trying to focus. Okay, please, just bear with me. 2 seconds.
Yes, Your Honor.
Did you or did you not make rental payments from 2011 on?
I was told not to pay rent.
Who
in a
told you
document.
not? Excuse me. Who told you not to pay rent?
John Mullins, John Phillips, the manager of Throgs Neck Houses. That
The
document.
manager of Throgs Neck Houses
Yes.
said, "Don't make any rental payments."
Yes, that we can't fix. It's in documentation. It was handed in that we can't fix the development.
And
You
I'm
have an
sorry, you
abatement?
submitted an affidavit from the manager stating that he told you not to pay rent for 8 years.
He put it in his handwriting. You do not have to
And
pay
this
rent.
is a part of the record.
It's a part of the record. It states.
Part of the record that was before the court.
Yes, Your Honor. It
Okay.
states Mr. Williams doesn't have. Mr. Williams, you don't have to pay rent until you get the
I'll
4
check the
transfers
record.
below 28th Street, which was ordered secondly
I'll
the
check
year
the
after
record.
by
Thank
the
you.
Honorable Judge Jaya
Thank you.
Medhaven. If I may add this, because this is important here. The New York Times, the Daily News, and the New York Post specifically says this about Throgs Neck Houses. This isn't about all the 5 boroughs. NYCHA managers ran complex like a jail. Daily News, NYCHA managers held boozy parties, retaliated against co-workers at Throgs Neck Houses, DOI fines.
Mr.
New York
Williams,
Post.
I'm from the Bronx, okay? I am well aware of what goes on in NYCHA houses.
Your Honor,
okay?
this is
So
just Throgs Neck Houses. I'm saying
I know what goes
corruption
on.
that was
We
there.
all know what goes on in NYCHA houses, okay?
Please value my
Mr.
life,
Williams,
Honorable Judge. I'm
I
telling
assure
that-
you, your record is going to be reviewed in full, okay? Unfortunately, we are out of time. I need you to trust that we are going to review this record, okay?
If I may say one last thing that's important.
Go right ahead.
I would do the same sacrifice that I did again. I'm a New York City Department of Education educator for 14 years. I took this fight for my neighborhood because we were dying in our apartments. I didn't have to. I had won decisions year after year after year after year, but when you find an organization that has no checks and balances, and they decide to send people to physically assault you, take your career. I was in a room for 5 years with no salary because they made a phone call off the records to New York City Department of Education and took
Okay.
my career. This is in my documentation of the retaliation.
I
They are
need you to
lying.
trust me that we are going to review your record. There's no way we can go over everything that's in your spirit and in your heart on this record tonight. I need you to just trust that I and my colleagues are going to follow the law, review this record, and render the decision that the law requires us to render, okay?
Yes, Your Honor.
Bless you.
If I could say one last thing. The evidence I can't put on record. New York City found 10 years to keep it off the record. The third-party documentation, this is just not me. They found 10 years to keep my words off the record, while they took years out of my life, called all their witnesses, and got the case dismissed. The history is in the case. It was dismissed 4 times without me speaking one word. How can that happen, that it gets dismissed after they took 3 years and had no evidence? They haven't proven to anyone how they came up with this money.
Thank you. Unfortunately, I have to move my calendar along, okay? Thank you. People versus Makita Knight. Counsel, you may proceed.
Good afternoon, Your Honors. May it please the court. My name is Mark Zeno, and I represent Appellant Makita Knight. The prosecutor's peremptory challenge to prospective juror Autumn Nelson, a black woman from Harlem with an associate's degree and 2 additional years of college, violated Batson. The prosecutor's explanation for his strike, that Ms. Nelson might have an issue about following the documents and the complexity of the case because she only had an associate's degree, was a pretext for discrimination.
Counsel, all the points that you raised in your brief, was that made in the record? While there was an initial application by counsel, the trial counsel, to raise this Batson issue, and there was some colloquy, and they gave what you contend to be pretextual response and not a race-neutral response for the challenge. All we have on the record is counsel noting an exception after the court made the ruling. There's no other elements here that suggest that the record, the brief that you're talking, and all the points you've raised here are there below, is there? Which would call into question whether it's preserved.
Right. What counsel did was enough to preserve the issue.
He says the only one who appears on the panel. First of all, there are very few African American jurors on this jury. The only one who appears on the panel, eligible for the panel, has now been challenged, and I would like a reason why this would happen. The court talks about, I disagree, but then asks the people if they have a reason. Then the assistant says, from the answers we got, there's a lot of kind of specific documents, and I believe she only had an associate's degree. We thought that might be an issue about following the documents and somewhat complexity in the case. Then the court says that Batson application is denied for the reasons given. Then they move on to other jurors, and then after, I don't know, the last juror is selected or the alternate is selected, then the counsel goes, yes, and Judge, may I simply ask with all respect, I don't know what that means, I do accept the court's ruling on Ms. Nelson. That's it. There is no statement by counsel that the reason given by the people was in any way pretextual. He says nothing. He just says, I accept. I don't, what does that mean, I accept?
Judge, the record is what it is, and preceding that, he does take exception to the court's ruling. It's my reading
the record is what it is, but that's the whole point. I mean, there's nothing for...
It's so frustrating because if we review it and think, perhaps this might have some teeth to it, and then we read the transcript and there's nothing. Nothing.
It is.
I need more than I take exception. We know by the case law that's not enough unless the judge has said something outrageous, and that's not what we have here. So either counsel needs to start making better records and stop playing so nice and say what they have to say so that we have something to review. But exception? That by itself is enough?
Judge, we're on the same page that counsel should make better records.
Good, I'm glad.
Not even.
And I hope this message is reaching
training.
the offices all across the city.
Better training, because it's not only that he says, he or she says, I accept, but he doesn't even, when the people say, oh, well, she's housing as an associate and the complexity of the case, the attorney says nothing. He doesn't say that's pretextual. He doesn't say that doesn't make any sense. I mean, I don't get from the defense attorney, what? Complexity. We all have bank accounts. We know how to check if money goes in, money goes out, where is it going? Nothing. I read this and I'm like, what complexity? How is this complex? I don't get it. But again, the defense attorney says nothing. He doesn't say anything.
Well, that's where interests of justice.
Yeah, you know what? And I totally agree with you in that we are all interested in justice and in doing justice. But by the same token, we cannot, make a determination based upon what should have been done, but what was not done.
But I believe on this record you can, Your Honor, because we have the full record. We have the prosecutor has had an opportunity to provide alternate explanations.
Well, not really, because, that's the problem. The record wasn't fleshed out, because if then counsel had said that's pretextual, then the people could have made further arguments. Counsel could have made further arguments, and then the court could have given a reasoned decision, and then we could review that.
I have 30 seconds.
Yes.
There was no further record to make, though. The prosecutor offered the reasons for his strike. He said she can't understand the complexity of the case. She only has an associate.
But he wasn't called out. You got to call him out.
Wasn't your prima facie Batson application really sort of weak, putting aside what you've heard about the lack of response to the DA's answer, but your initial application is just, I got to question that. I mean, there's no showing of who was in the jury pool, where this, on the face of it, seems to be a Batson issue is just, you say to the judge, I got to question that. I mean, I want an explanation for it. I mean, isn't there a requirement that in making the application that you come forward and say, look, this doesn't look right for the DA to be taking this Batson challenge because look at the pool, look who they've let in, why are they not letting in this juror? You've got a very weak application in terms of the record.
Well, the court can't revisit. Once the judge asks the
judge seemed to have been tempted to just, because of the weakness of the application, to just summarily deny it and then thought better of it.
Well, if there was a summary denial for prima facie grounds, then we'd be arguing it would be a different case here. But if it were the only black juror remaining on the panel...
That's certainly all on defense counsel to make that case.
Yes, but this court, while this court is powerless to revisit the prima facie case ruling, it does have interests of justice authority to visit the obvious error that occurred here with respect to whether this was a pretextual explanation or not. And, my colleague here can address with the court why it isn't. I've seen the explanation on paper, and I find it dubious.
Thank you. You may proceed.
Good afternoon, and may it please the court. Peter Rienzi on behalf of the people. As your honors have pointed out, as the moving party in the Batson challenge, the burdens were on defendant to persuade the court about the issue of pretext and to make
Is it relevant at all that before the prosecutor even had an opportunity to open his or her mouth, the judge immediately had already kind of dismissed the application?
Judge, we certainly would submit that is relevant. Certainly in terms of the court reviewing the question of pretext, obviously there are decisions, this court and the Court of Appeals saying that...
Your fallback position is that it's not pretext because, in fact, this was a case with 1,000 pages of documents admitted into it and 45 different exhibits, and therefore the reason was not pretextual, that factually it's not pretextual, although clearly it's not the best reason that's ever been given.
Especially in light of the fact that there were 2 other jurors who didn't have college degrees that were placed on the jury.
3. Yes, Your Honor. However...
So the you don't have a college degree doesn't really stand the test, the smell test when you have 3 others who are on the jury who likewise don't have college degrees yet were seated.
Well, she had an associate's in fashion. So
yes.
And she also said that she was a business owner as well, a story or something like that.
I don't believe that Ms. Nelson, the juror in question, I don't believe was I didn't take from the record that she was a business owner. I thought she said that she
had some kind of business.
I think she worked for a design company.
She as a fashion merchant. She was a fashion merchandiser at a company called Story.
Yes.
And had associate's degree in fashion merchandising and 2 additional years of college of education in that field.
Yes.
Which would, again, you're talking about fashion. She appears to be in a business, which would lead me to believe that...
And in merchandising, that means that you're buying and have the ability to order stuff for your company and invoices and have the capacity to pass along charges to your company, kind of like what was being tried in this case.
Right, with a PayPal account.
So I don't understand why her lack of an education, her lack of a BA, because she had an associate's,
Yes.
was such a problem when we had two others on the jury who likewise didn't have bachelor's degrees, but yet they were okay.
And well, this juror lived alone, had never been the victim of a crime, no one in law enforcement, et cetera, where the other individuals who did not have a college degree had been the victim of a crime. Interesting.
Yes. So,
Well, that would be a reason why the people would want that person as a juror, that they'd been a victim of crime.
And not this juror who had never been the victim of a crime.
That's a bias for the people, not against the
I
defendant.
mean, I think that the people probably prefer to have a juror that's been a victim of a crime as opposed to a juror that hasn't been a victim
Actually,
of a
it's the opposite.
Yeah.
You usually don't want the victim of a crime because you don't want them using their victimhood against the defendant in question.
Your Honor, if I may, I think that obviously the comparison between the jurors who were seated and Ms. Nelson was not made, as we all know and have discussed, on the record. So that did deprive the prosecutor of the chance to explain further the juror versus juror comparisons that.
Would it also be clear on this record that the defense counsel was not cut off from making any kind of argument in support of the Batson challenge? The court in no way hosed the defendant down based on the reading of the record.
That is certainly our position, Your Honor, yes.
Yes, but before the prosecutor even uttered a word, the judge immediately said, I don't see that there's a Batson challenge. Well, what do you have to say, people?
Right. Your Honor.
Talk about putting your finger on the scale a little bit.
I would just note again that obviously that comparison was not put on the record, and therefore the record is incomplete with regard to that. We submit, as we argued in our brief, that there were multiple reasons why those particular jurors may have seemed attractive to the people in this case. Your Honors, I'm happy to answer any other questions that you may have. Otherwise, I will rest on our brief.
Thank you so much.
Thank you.
You have 2 minutes, counsel.
I still haven't heard a non-pretextual reason for striking.
But this is not the time to hear it. It was during the voir dire. That's when you needed it, not now on appeal. Right?
My client,
A couple of
Nikita
years
Knight,
short.
a black woman, was tried by an all-white jury. One of the jurors, prospective jurors, was struck for what's clearly a pretextual reason. If that doesn't invoke this court's interests of justice powers.
I have great respect for you. But to put on the court the onus of preservation, of giving the court the meat it needs to make the decision you want us to make is really not fair, okay? Because we have to follow the law too. So again, my message is preserve your record and stop being nice. If you think there's a Batson problem, preserve it, say it, do everything you have to put it on the record so I actually have some meat on the bones to sick my teeth into, okay?
I hear
Thank
you,
you.
Judge.
Please send that message. G&Y Maintenance versus McSam.
God. You're killing me.
Good afternoon. My name is Jerry Toth.
Hold on. All of your colleagues aren't up here.
Okay.
I appreciate your eagerness. Now you may proceed.
I represent G&Y Maintenance. My client, G&Y, is a sub and material man. G&Y worked to build a 28-floor hotel. A large hotel developer, McSam, sold the completed hotel for $85 million. This case concerns a GC's underpayment of subs. The GC induced.
What impact, if any, does our recent decision in GNY Maintenance versus Core Continental have on this case?
It's absolutely relevant. In fact, Your Honor has already heard basically a very similar case in which you ruled that all claims should not have been dismissed against Kyung, the GC owner. He did it in this case, precisely the same thing in that case. In fact, there have been 3 cases where courts have, this is the 3rd case where Kyung employed a sub without a contract and then left the sub underpaid. And 2 previous courts, including that case, ruled that Kyung's conduct was inequitable.
But I think we need to focus on the core issue here. Essentially, while you weren't getting the money you were supposed to get, what makes this case timely? Because you're challenging the dismissal of the case.
Absolutely.
And so how does this fit within the 6-year statute of limitations to make it timely?
Precisely. My client, the defendants did not appeal the lower court's finding that my client worked until April 2014. There are uncontradicted affidavits by workers that they worked until April 2014. There are receipts. I think these are exhibits H and I to the Second Amendment complaint, documentary evidence that my client worked until April 2014. And
When was the last, let's try to focus this. When was the last invoice that your client sent for payment on work on this project?
Those were,
Let me help you.
I believe
think
in-
it was sometime in 2013.
It
Would that sound correct to you?
Yes, no, 2014.
Okay, so then tell me, you will have time. I'm going to give you 1 minute on rebuttal because I want you to get back up and tell me what invoice, where in the record shows that there was an invoice issued in 2014, and tell me where I can find that in the record.
Okay, it's a great question, which I don't have it in front of me, but the issue here is that my
Counsel,
client
with all due respect to you, we get to decide what issues we think we need to decide, right?
Yes.
And I let you argue, and you made your arguments, and I asked you a question concerning
So
what was...
are you saying that the issue is accounts payable? But
No, what I'm saying is that when the statute of limitations, the 6-year statute of limitations begins to runs from the date when it was due. And so...
True. You're absolutely correct for an account
so
payable.
I need that date from you.
But for breach of fiduciary duty, for unjust enrichment, it runs from April 2014, the date my client completed work. Also, there was a continuous fraud even after my client finished working. So my position is that the statute of limitations is no problem here because the August 2020 complaint was timely, given the executive order which the lower court failed to address or discuss.
The last payment you received was on March 11, 2014. Isn't that so?
Sounds correct, yes, sir. I would surrender the accounts payable issue.
Why doesn't the statute of limitations run from that day?
Well, my client continued working till April, and the fraud continued until after April. And in a construction contract, the time of completion of work is when the statute of limitations accrued.
Say that again.
Even lower court,
No, wait. Say that again, what you just said.
In a construction contract, the statute of limitation accrues at the completion of the work.
It does?
No, I'm afraid I disagree with you.
I didn't think so.
Is it a question of opinion or of law? I mean,
You know what? Unfortunately, you don't get to ask the questions. It's the other way around. But you research that and see what you find.
my brief does
Okay?
address that, yes.
All right, come on up. Next.
Good afternoon, Your Honors. Adam Marshall, Kaufman Dalowich LLP for Respondents McSam and RS 206. I first want to deal with the statute of limitations issue and be clear about this. There is no breach of contract claim asserted against my clients. The only cause of action asserted
You're representing?
McSam and RS 206.
Got it, okay.
So we're not the GC. The GC is CORE. There's a principal of CORE who's also been named. Think of my clients as the owners. The only cause of action is unjust enrichment, so regardless of whether or not GNY says it has a contractual arrangement to bill at a certain time and certain amounts with CORE, the operative issue for my clients is unjust enrichment. When does an unjust enrichment claim accrue? And as Justice Friedman pointed out, the court just dealt with that issue under almost identical facts. It's the date of the last invoice. The date of the last invoice in this case, and I believe it's in the record at page 152, is September 1, 2013. That's the last one. And that corresponds to allegations in both the amended complaint and the proposed second amended complaint, which was treated as the operative pleading in the decision below. GNY says, I'm seeking $250,000 for the last 5 consecutive invoices. Now, although there was discussion by GNY about 2 change orders subsequent to that, and GNY pointed to affidavits from 2 workers saying, I was on site in or about March or April of 2014, those change orders were not tied to any cause of action in the complaint. The allegations in the complaint are, I am unpaid for these invoices. And the last one is September 1, 2013. So the 6 years runs from September 1, 2013. It expired certainly against my clients in 2019.
So there's no breach of contract claim against you?
That's correct, Your Honor.
So your adversary is claiming continuing fraud?
Not by my client.
So what?
The issue, Your Honor, is that, and we've listed it in our brief, and it was very clear, even laid out in the pleadings, that the allegations of continuing contact between the plaintiff and any defendant was with CORE, was with the general contractor. The invoices were sent to CORE, the demands for payment, the alleged...
Plaintiff is claiming some type of continuing relationship with your client as well.
No.
So you're saying that the work for CORE also did not relate to properties owned by your client?
Oh, of course it does.
So then it is connected.
Well, it's...
Come on.
Well, Your Honor, the case law on that issue is a property owner does not become liable to a subcontractor when there's a contract.
I didn't say liability. You said we weren't connected.
There's no... Well, Your Honor, there's no continuing...
He continues to do work for CORE, and CORE is doing work for your properties. You don't see a connection there?
Well, Your Honor, let me, if I may, address that. The continuing contact is after the work was completed. So there's no request for payment from my client. I can't speak for the conversations between CORE and the subcontractor. So that would be my response, and we respectfully rest on our brief. Thank you.
May it please the court, Brian Levine Singh, LLP, appearing for Core Continental Construction and Chunling Chiang.
So he seems to be saying that he was doing work for you in April of 2014.
So, Judge Friedman, whether he was still doing work at the project with respect to change orders has nothing to do with the damages being asserted in this case, has nothing to do with the contract.
So are you saying that he pre-billed for work he was doing on change orders that happened? Let me finish my question because I'm sure you cannot read my mind. Okay, so you're saying that he billed ahead of time for work done after April. Is that what you're arguing?
That would be the only conclusion that could be reached with respect to what they would be arguing.
No, you were saying that irrespective of whether he continued to work after April, and I cut you off, right? So my question to you is, are you saying that he billed before, that the last bill was in September, according to your
2013.
colleague here, right? So there was a bill in September that added for work being done in April?
No, between
Okay.
December.
So the work that he did in April, because I haven't heard you deny that he worked in April. You
I haven't
said
gotten to that yet.
irrespective
No,
of.
because that's not what, so with respect to the April 2014 date, that has nothing to do with this claim against my client. It at best was raised in respect to the unjust
No,
enrichment
so let
claim.
me ask you a very clear question. Did the plaintiffs work in April of 2014? Were they still working in April of 2014?
Under this contract, no.
Under
Under-
what contract were
It was
they
a
working?
separate contracts.
For this building?
Yes, there were separate contracts. If Party A hires Party B to paint their house blue in January for $5, okay? And Party B paints the house by January 15th, that contract is complete. Now, say Party A is so happy with the work of Party B that in May, they hire Party A to build a deck for $10. Just because now there is a new
That
contract.
sounds like a runaround the statute of limitations.
No,
That's
but
what that
that's-
sounds like to me.
No, they're separate contracts.
How
This is
saying
convenient.
that this
It's not
complaint,
conveniency here.
this complaint relates to pre-April work.
I'm sorry?
That this complaint
Exactly.
relates to pre-April
All of these invoices are for
work.
work done between December 2011 and September 2013. Nothing in this complaint has to deal with any of the change orders. It has nothing to do with any of the other contractual agreements that the parties entered
There are a
into.
lot of contracts between you and the plaintiff on covering different buildings.
Yes, they have different buildings, they have different property owners, they're different projects.
And different contracts for every single different project?
Of course, because they would have to be. They're separate entities, they're separate owners, they're separate properties. You hire,
So in the record, do I have the evidence of what he was working on in April that had nothing to do with this, according to
yes,
you?
yes, I believe he points to a change order, which he refers to in his brief as being a subsequent.
So how is
second,
a
and third
change
agreement.
order
It's
a
not.
separate contract?
It's not a change order, and that's the point. Just because he arbitrarily refers to something as a change order, which is a term of art.
Oh, I
under the
know, that's why
AIA
I'm
agreement.
asking.
It's not, it's just another oral agreement.
So oral agreement?
That's what this is.
So he claims that work was continuing in April of 2014. April 14th is when work was April 14, 2014 was when the work was actually completed.
Under the second agreement that they entered into, they were finished. As of September 1st, 2013, they were finished with their first agreement and with the work. Apparently, they had other work. After they were done, months later, they had work that they came back to the property to perform, that they were hired to do. They, according to.
So the way
appellant-
you just said it implies that there was a separation of time,
Yes,
right? So they've completed one job, they're off the site, and then they get called back in for another piece,
yes.
okay?
And that's,
And this complaint is about the first piece.
yes, and that is why everything is untimely.
Got it.
And
Okay, thank you.
thank you.
I'm giving you 1 minute.
Okay, Mr. Levine did not appeal the case below. The judge found, just as my client asserts, one contract, one agreement. My client made one claim, $500,000, didn't claim different amounts.
Is there anything in the record which reflects why you waited all these years to bring the action? I mean, usually when someone finishes a job, whether it's 2013 or 2014, they don't wait till 2020 to bring the action.
We brought an action in 2014, mechanics lien, and it got dismissed. Then we
Was
brought.
that the order by Judge Hagler?
Yes,
And it was without prejudice to you filing an action?
exactly.
And you didn't do it until 2020, correct?
It was
That's-
timely in
that's like 6
2020, less
years.
than 6 years after finishing work. A
No,
timely
it's
action.
6 years from when you demand payment. I mean, in other words, you just said the $500,000 you're seeking is from invoices for 2013 contract, correct?
Well, we're not, I'm not claiming account payable, I'm claiming payment
But you
for
said
work.
that before, but that was what I was saying. It's 6 years from when payment is due.
Less than 6 years, yes. Because it was the
No, the statute
the
is 6.
Executive Law 202.8 added 228 days to the time from April 2014 to, I still had another 160 days to file before after I filed. My claim was this is a foul and nasty breach of fiduciary duty that the parties work together without any writing, without any agreement, in a relation of trust and
General
confidence.
contractors and subcontractors have fiduciary duties? There's a fiduciary duty between a general contractor and a subcontractor?
Yes, it was in this case. In this case, my client relied on Chong's representations and did millions of dollars of work without any writing. It was a trust of confidence. And then the time came in 2013, 2014, when my client was working on 3 projects.
It might be a trust of confidence, but does that constitute a fiduciary relationship or fiduciary duty?
All of a sudden, Chong stopped paying at 3 construction sites, $745,000. This case concerns one of those sites for $250,000. So there was
And then you wait almost 6 years to seek payment?
less
Thank
than
you.
6
Or maybe
years.
more than
The
6
case of
years.
Counsel?
Basil
Coun-
Training v.
counsel?
M&G Diamond.
Counsel?
Yes.
We have your briefs and the record. Thank you.
Thank you for this opportunity for justice.
You are so welcome.
All this justice today is crazy.
Landa versus Friedman.
Good
You may
afternoon, and may
proceed.
it please the court. Michael Hiller on behalf of the plaintiff appellant, Gold Landa Trust. This court has unanimously already rejected the very defense that the lower court mistakenly allowed below, specifically in Peacock Holdings versus Keefe and Keefe, Inc. This court, in affirming the grant of summary judgment in lieu of a complaint, ruled, and I quote, "The IAS court properly rejected parole evidence to show that the promissory notes and security agreements in issue were fraudulent shams to defraud the IRS and entered into what was actually a gift, or at most a conditional loan, look like an unconditional promise to pay." I would refer you to Record 7, where the court relied on the very defense this court rejected in Peacock when the court ruled, in his affidavit, defendant alleges that the $269,287 provided by the trust was intended as a gift and not a loan. It's the very same defense. Now, the
How
law-
is it clear and no triable issues of fact that this was intended, that the notes were intended to be paid?
I'm sorry.
How is it clear that there are no triable issues of fact that the notes, in fact, were intended to be repaid?
Well, the promissory notes themselves stand on their own. And what Your Honor is asking about is whether or not there was an oral promise, an unexpressed oral promise from the payee to the maker of the note,
Is it
essentially saying, I don't...
Is it so unexpressed when you consider the unusually low interest rate, the nature of how this is set up? Does that not when you take all the circumstances together, does that create an issue?
There are a series of issues, but I know of no case in the state of New York in which a low interest rate is sufficient to convert something from a gift
Not
from a
by
loan to a
itself.
gift.
Not
by
by
itself.
itself, but the way it's set up, the $28,000 amount in each note.
Well, this certainly is the case that there are circumstances. I agree, there are circumstances here that are somewhat unusual, but they were also unusual, for example, in the case of Genger versus Genger, this court's decision in 2014. In that case,
But why isn't the affidavit of Alexander stating what he professes was the arrangement, why doesn't that by itself create an issue of fact together with all the other peculiarities of the case, right? So the 14 and 14 equals 28 to provide us with a gift tax exemption. All of those seem to kind of fall into place with the statements of of the defendant here. So why is that not an issue of fact that the court should consider?
Well, there are two questions before the court. One is a question of law and one is a question of fact. The first question before the court is whether or not, in response to a motion for summary judgment...
Can you answer my question, please?
Sure. With respect to Mr. Friedman's affidavit, if you look at Record 35, Mr. Friedman specifically says, and I quote, "At the time of the signing, Landa walked me through the schedules and explained how each note was to be written off each year." He later on Record 36, specifically says that the loan was going to be forgiven. Now, in order to be forgiven, the loan had to have existed in the first instance. In order for the monies to be written off each year, they first had to be written on. If you look at his affidavit, he
But how is
acknowledges...
that inconsistent with his ultimate position?
Because in order for it to have been a gift, it couldn't have been forgiven. By definition, a loan is forgiven, is not a gift. His own affidavit, in other words, as a matter of fact, undermines the fabric of the very legal argument his lawyer has aspired to create.
Is he a lawyer?
I'm sorry?
Is he a lawyer?
Mr. Friedman a lawyer?
Yes.
I don't know. I'm sure Mr. Constable will be able to answer that question for you, but I'm sorry, I don't know.
Okay.
But I do want to emphasize to this court that Mr. Friedman, who is certainly a sophisticated individual, specifically says in his affidavit that the monies that were paid to him and the amount due in return would be forgiven. By definition, if it's going to be forgiven, it was first owed. If monies are going to be written off, they first had to have been written on. But I would go further, one step further, and I would ask, if I leave you with one enduring thought on this argument, I would ask you to look at Ganger versus Ganger, because Ganger versus Ganger is on all fours with this case. In Ganger versus Ganger, a son made a note to his father, and two notes to his father. And after the parents got divorced, the son sided with the mother. The father then belatedly began to enforce the promissory notes.
There we said that the allegations were conclusory and unsubstantiated.
Right.
Are the allegations here, would you characterize the allegations here as conclusory?
And we never said that defense, we were barring that defense as a matter of law.
I would, with respect, Justice Weber, I would say that in Peacock, this court did rule that the defense fails as a matter of law. And I read you verbatim what this court said in 1996. But if I may just, before I close, just one final thought with Ganger versus Ganger. The son sided with the mother. The father then enforced the promissory notes, at which point the son said, "I was never supposed to repay these notes. There was an unexpressed oral promise that I was not supposed to repay these notes because there was a tax consideration to avoid the gift tax." This court enforced the notes. There was a daughter in Ganger who also signed the notes. She was a non-party. The father never sued her, and this court said that didn't matter. What matters simply is what the notes say, and these notes are unequivocal insofar as they provide an unconditional promise to pay a sum certain on particular dates, and on that basis, the plaintiff was entitled to summary judgment. Thank you for your time.
You may proceed.
I believe it's evening, so I'll say good evening, Your Honors.
Good evening.
On behalf of respondent, and although it's not in the record.
It's not 4 o'clock yet, sorry.
Oh, really? Oh, okay. Okay. So we're,
Evening is 5 o'clock.
we have plenty of time.
Evening is 5 o'clock. 4 o'clock is still afternoon. I mean, I know the sun sets at 4, but still.
Well, it's not in the record. I can tell you that Mr. Friedman is not an attorney.
Thank you.
Now, the
Interesting argument, though, that if it was a gift, then it wouldn't be forgiven.
It is. Okay, so, and it's important to consider why that is because this is for one lump sum payment. And so if it was an immediate gift and that entire lump sum was forgiven at one time, it wouldn't remain under the gift tax. And so each note, which encompasses this entire payment.
I understand what you're arguing. Yeah.
None of this is in the notes, so how does this version of events that you give us, how does that square with the parole evidence rule?
Sure. So one, it's very clear, especially these courts holding in Greenleaf, in Polygram Holdings, in Valford, where you have so-called parole evidence that is not meant to contradict the terms of a contract, evidence which is put in the record to state that the contract was never a contract to begin with, the parole evidence rule simply never applies. And Your Honors, in Greenleaf, that is the case that's on all fours. That is the case in which the plaintiff was attempting to enforce promissory notes. The defendant had provided an affidavit and said, no, this is really a tax-saving device, and explained how that was done. The court in Greenleaf, this court, then looked at that and said, well, the parole evidence rule, there's actually an exception, where if the so-called parole evidence is meant to basically be evidence that the contract never existed to begin with, it's admissible. Now, in our brief, I go through a long, from like 1875 Court of Appeals line of cases. It's really not the exception. It's just that that's not the parole evidence rule. The parole evidence rule is only meant to prevent contradiction or somehow putting into question terms of a contract that are clear. This is not that case. This is to say this contract never existed.
So do you agree?
Now, it's not that it didn't exist, but that the language of the case says there are some exceptions to this rule, which allows the admission of parole evidence not to vary the terms of the writing. So you can't use parole evidence to say that's not the term I agreed to, but you can utilize parole evidence to establish that, in fact, the writing, which although purports to be a contract, was in fact no contract at all. So that's what Greenleaf stands for.
Correct, Your Honor.
So you're saying the promissory notes are not really promissory notes?
Correct, Your Honor. And let's...
So how do we reconcile Ganger then?
I'm sorry, how do we
How do we
reconcile
reconcile Ganger?
Well,
So do you read Ganger the same as your adversary?
Yeah, sure. I think Justice Friedman hit the nail on the head. This court in Ganger looked at the affidavit that was provided and said, this affidavit has insufficient evidence, it has insufficient detail. You're saying this was a tax-saving mechanism, but you haven't described why. It's not clear. Now, it was so clear in this record, Justice Bannon in the court below was able to, in 2 sentences, describe how these notes operated as a tax-saving device. But before we even get to this, what's called the gift fraud defense, and this question about whether or not parole evidence can be looked into, it's important to look at the record, Justice Bannon's order, page 6, in which Justice Bannon looks at the circumstances, not parole evidence. She looks at how is this note enforced. We have Elizabeth Friedman, who is a co-signer on the note. It was not enforced against her. The first note was forgiven within months. The second note is not being enforced. And it's not being enforced because the statute of limitations has lapsed. The remaining notes were not enforced until the divorce proceedings below. And Justice Bannon, in her order, and this is before she even gets to the question of Mr. Friedman's affidavit, in which he lays out basically everything that was said to him, Justice Bannon says, these facts alone, including the notes themselves, present factual issues as to whether the funds were intended as a loan or a gift. Your Honors, I see my time is up. If there's no further questions, I'll submit.
Thank you.
Thank you.
I'll be very brief.
No, counsel, I had a procedural question.
Sure.
Elizabeth and the defendant both were parties to the promissory notes. Is that correct?
That's correct.
Well, why isn't Elizabeth a part of this lawsuit as well?
Yeah, Your Honor, I would say, and I'm not trying to dodge your question, but any answer I would give you would be towards the record. I don't know, but I will tell you this.
Well, I was wondering whether at some point in time she was a party and, she somehow was,
No, Your Honor, but what I would say to you, though, is that in Ganger, the same circumstance existed. That
Ganger is one of your favorite cases.
Yes, it is. It is my favorite case.
Yeah.
The other thing I want to mention to Your Honor is that I didn't mention on my initial presentation, but opposing counsel has raised the point. The promissory notes contain an interest rate, and most importantly,
0.1%,
which was applied
0.
and which was paid. That is entirely inconsistent with the notion that it was a gift. That is
0.1% is nothing. The principal was $28,000. So what's 0.1%? Like
Well,
$2?
$4.82, Judge. But what I would say to you about that is that a promissory note could have 0% interest and still be a promissory note. It doesn't convert it into a gift. And the fact that...
But again, there are cases, and it's not Ganger, it's another case, that talks about the fact that there was a promissory note that had 0 interest, and that is something to be considered in terms of parole evidence.
I understand that, but in order for this court to consider parole evidence, you would be required to consider that there is an oral, unexpressed promise not to collect the note and not to prosecute it. And that would require this court, for the first time, by the way, to be in a situation where you're taking the express terms of a note that says it's an unconditional promise to pay, and you would be relying on an oral promise not to enforce the note. And I would respectfully submit to you that if that were to be the case, if people were allowed to say...
But you are suggesting that under our case law, we are not permitted to review the circumstances around a contract, a promissory note, to determine whether, the first question, whether this is a real contract, which is what the cases say. So parole evidence cannot be used to alter, vary, amend, modify, change in any way the terms of a contract. It can be used to determine whether this is a real contract.
I hear you, Justice Madden.
So I don't see how you're getting around that with your arguments.
What I would say, I would leave you with this, and I promise I won't talk about Ganger versus Ganger again, but I've got a better one. I'm going to return back to the Peacock case, and I would respectfully ask you to review the language at page 331 of that case, because in that case, the very argument that the defendant respondent made, the very same argument was rejected. And it said, and I quote, the trial court, quote, properly rejected parole evidence to show that the promissory notes and security agreements in issue were fraudulent shams to defraud the IRS, entered into to make what was...
But that's not, sir, that's not an issue here. Nobody's claiming that this was intended to defraud. They wanted to use this as a tax scheme while it being a gift. Where's their fraud?
Families do that all across America every day of the week.
Oh, what I'm saying to you, Justice Shulman, is that is exactly what was alleged, specifically that our client was trying to make this a gift rather than a promissory note. So, I'm sorry, make this a promissory note rather than a gift to avoid the gift tax. That is exactly what the defendant is saying here, and that is exactly what the defendant said in Peacock, and this court refused to accept it.
Okay.
Anyway, I thank you for your time.
Thank you so much.
Enjoy your evening.
You too.
Afternoon.
People versus Nate Miller.
It's cute though, I like it.
You may proceed.
Good afternoon. My name is Lindsay Campbell, and I'm a law student intern appearing with the Office of the Appellate Defender on behalf of Mr. Nate Miller. The prosecution in Mr. Miller's case incurred time far in excess of the 184 days under CPL 3030 that they had allotted to prepare for a case with 2 days of testimony, 3 witnesses in total, and absolutely no expert testimony, and the lower court in error only charged the prosecution with 131 days. Now, over the course of the 3-year pretrial period, 4 adjournments were improperly excluded and should have been charged to the prosecution, 2 of which are particularly important. The first
Were
being-
all of those dates preserved?
No, Your Honor. The first I'm discussing was preserved, and the others were asking to be reviewed in the interest of justice.
Okay.
The first was the 41 days that were chargeable to the prosecution insofar as it failed to exercise due diligence in procuring a key witness, Mr. Nicholas Romero. The court excluded this on the basis of CPL section 3034G, which only allows that exclusion to apply once the prosecution has demonstrated that they've exercised due diligence. Not only is it unclear from the record if they were in contact with Mr. Romero, but once learning of his incarceration, they made no discernible efforts to extradite him and secure his testimony at Mr. Miller's trial.
So this is the February 25th, 2016 adjournment, right?
Yes, Your Honor.
So February 25, 2016, it was adjourned to April 6, 2017 for trial.
Yes, Your Honor.
People claim that they provided documentation to support their assertion that he was an interested witness, he was incarcerated, as you stated, in California, and that he would be released in March 2016. So what more should have been shown?
Yes, Your Honor. We're arguing first that they need to establish that they've exercised due diligence to secure that testimony at trial. It's only by
People know that
happenstance.
someone is incarcerated and if they expect that he's going to be willing to come to New York to testify, if they know he's incarcerated and he's about to get out of jail within the next 30 days, do they have to do more? I mean, it's not like they're going into California and they're getting him tomorrow. It's no matter what going to have to take time to get him out of jail there and bring him to New York. Is that an unreasonable delay when they say, okay, we're going to wait 30 days in order to get him? Because some of that delay was caused by the fact that counsel for Mr. Humphrey wasn't available. 11 of the days was for that, right?
It wasn't excluded on that reason, Your Honor, but moreover, what we're arguing today is that due diligence would not be satisfied, as this court has stated.
If you know what
Douglas.
someone's
The people-
about to be released from prison, you cannot wait for that release date in order to bring him to New York.
Your Honor, in this case, the prosecution made no efforts to subpoena him, to serve the corrections officials who were looking over the carceral facility
But
where
that's the
Mr.
point. Why should they when they know that he's going to be released in the end of March? This is February 25, 2016, right? And so they're saying, they're just requesting, I'm sorry, this is, yeah, they're stating that he's going to be released by the end of March. So
Yes,
if
Your
he's
Honor.
going to be released within a certain period of time, what due diligence is there to be shown? Now, I could see that if he's going to be released in July or something of that nature, then you're going to say, oh, well, you know, we've made arrangements with California, or we're attempting to get a warrant or what have you, but it's 30 days. What else could they have done?
Yes, Your Honor, two responses. The first being that the exclusion only applies under the plain language of the statute when that due diligence has been shown. And what we're arguing is that at this point, the court had already excluded 195 days on the
Do
basis
you
of
have to show
reasonableness
due
to prepare for
diligence? Do you
trial.
have to show due diligence for something that's about to happen anyhow?
Yes, Your Honor. They have made no efforts to, again, make travel arrangements for Mr. Romero. They made no efforts.
But again, look, if he's going to be, it's going to be cheaper for the state to buy a plane ticket to have him come to New York to testify, not being in jail, than having to go through the entire correction process and having court officers escort him to the plane, have escorts with him on the plane. You see how it exponentially becomes much more expensive. So why is it unreasonable in light of the short adjournment of 30 days to make that wait for him to be released in order to make the arrangements post-release?
Your Honor,
They did arrange his travel, didn't they?
they did once he was released, but they had made no
Right.
efforts prior to this date to.
And also, it's due diligence to secure the witness's appearance at trial. So the due diligence here that was exercised by the people is locating him, knowing he's in California, knowing that he's incarcerated in California, knowing his release date is going to be sometime by the end of March 2016, and then knowing, therefore, that he's going to be able to come to trial.
Your Honor,
So
we've seen in other contexts that are comparable that the state has to exercise due diligence, such as subpoenaing people who might be unavailable, say, because of military duty. But we still found that they must be subpoenaed.
Because the military requires a subpoena in order for it to release its members. I mean, that's the procedure.
And that has happened too when people are in medical treatment, so long as removing them from medical treatment would not impede the treatment itself. And insofar as bringing Mr. Romero to testify at Mr. Miller's trial would not necessarily impede whatever sentence he is serving, we believe that the state should have exercised due diligence prior to this date, where they're asking for it to be excluded, and demonstrated that they did, exercise some efforts to procure his testimony for Mr.
I'm going to give you an extra minute because we asked you so many questions about this one issue and you haven't gotten to the others. So I'm going to give you an extra minute. So hit the other issues, okay?
Yes, Your Honor.
Go ahead.
The second adjournment we'd like to discuss is the 77-day adjournment, which is too lengthy according to this court's past precedent and as even addressed by respondent in briefs. This is 28 days longer than the longest period of time that this court has recognized as reasonable to prepare for trial, which is the basis on which this exclusion was granted. For example, in People v. Hayes, the court upheld...
Because this isn't preserved, is it?
We're asking that this be reviewed in the interest of justice, Your Honor.
It's not preserved.
It's not preserved. Counsel did make record of objections to this in multiple CPL 3030 motions, and while she did not file additional responses to the prosecution's reply brief, we'd ask that given the extraordinary length of this delay, as well as the...
So what date is this? Is this the December date?
December.
Yes, Your Honor.
This is a December, and it's adjourned until, I think, March? Or
February 25th.
February 25th. And the records, apparently, there's no transcript of why it was adjourned to February?
No, I don't have a specific reason for that, Your Honor. But what I can say is that this was a garden
People were
variety
charged
robbery
with 25 of those days, right? Out of the 77, the people were charged with 25 days.
I don't believe people were charged. I'm not sure, Your Honor. I'll get back to that on rebuttal.
Supreme Court didn't charge the people with 25 days for that?
I will get back to you with that rebuttal, Your Honor.
I'm looking at the court's 3030 decision.
We'll take a look at that, and in the meantime, we'll hear from
Wasn't preserved.
counsel for the people.
Good afternoon, Your Honors, and may it please the court. David Gagne for the people. So to begin, all of the 3030 claims are unpreserved, and that includes the claim regarding the adjournment for the exceptional circumstance. Counsel below did not raise the issue of due diligence with respect to this contested adjournment. So all of the claims would have to be reached in the interest of justice, but Your Honors should not reach it. Regarding that adjournment, the people established that the witness was incarcerated in California.
Do we know why the witness was incarcerated in California?
Why he was?
Is there anything in the record as to why the witness was incarcerated in California?
He was serving a sentence. I don't remember the nature of the crime, but he was serving a sentence. He was not in pretrial detention. And given the fact that he was to be released within 1 month, the people satisfied both the due diligence and requirement, as well as the requirement that they...
I want to turn your attention to the other aspect of the appeal. Is People versus Weathers a problem for your conviction of the defendant based upon the fact that it's Humphrey who has the metal knuckles and the defendant says, I didn't know that he had them?
Your Honor, People v. Weathers is not an issue for us. The Court of Appeals in People v. Miller, this court in People v. Cruz, every other intermediate appellate court in New York have addressed this very issue, and they've made it very clear that a defendant need not be aware that the co-defendant was armed with the deadly weapon in order to be guilty of first-degree robbery. Weathers could not be a repudiation of all of these cases because the issue was not fully briefed in Weathers. I went back and looked at the briefs in those cases. The defense raised a number of issues as to the weight of the evidence claim. The people responded in one sentence to the claim that the defendant did not know that the co-defendant was armed. And they actually did not raise Miller, they did not raise Cruz, they did not raise any cases. So the court in Weathers simply was not fully briefed on the issue. And so to the extent that Weathers is inconsistent with any of those cases, it should be disregarded. Unless there are any further questions, I ask that you affirm. Thank you.
Thank you. You may proceed.
To begin, Your Honor, first, there was no charge of 25 days in that 77-day adjournment against the prosecution, so the entirety of the 77-day adjournment was excluded. We again argue that this is an extraordinary lengthy amount of time for a garden variety robbery case, and that there was a practice in this case of continuing to uphold adjournments or exclude adjournments on the basis of reasonableness when this was a case that was relatively simple for the prosecution to bring. We also presume in this instance that the court, when they decided Weathers, was aware of the other case law that existed and rather used that as an element of their power of factual review, which we ask that this court do similarly for Mr. Miller's case insofar as there were no evidence presented that Mr. Miller was aware.
On that particular adjournment, that was the first day, the first adjournment following the omnibus decision.
Yes, Your Honor.
And typically, there is some amount of time, 30 days, 35 days would not be abnormal, and certainly not so during the Christmas recess, which this adjournment kind of fell right before, right? So are you arguing that the entire 77 days should be chargeable?
Your Honor, respondent made no arguments that it shouldn't be that it should be broken up in any sort of way. We are arguing
Well,
that
they're
the
saying it
entire-
should be totally excluded, so I'm asking you, out of the 77 days, because based on the posture of the case, seems to me it would not be a reasonable argument by the defense to say all 77 days following an omnibus motion decision that grants a map done, Huntley Dunaway Wade hearing. There's some time, I mean, it doesn't seem to me like on this case there was huge issues on these hearings, but still it requires getting your ducks in a row, right? So at the very least, a 30 to 35-day adjournment over Christmas recess following an omnibus motion decision would not be unreasonable and fitting within the case law. Would you agree?
Your Honor, we're contesting the entirety of the adjournment, but I don't disagree that those numbers are more reasonable, considering, for example, the 39-day adjournment, which the court still said was arguably too lengthy for a case with numerous defendants and evidentiary issues, as well as a 49-day adjournment was upheld, being the longest in this circuit, or this court, for an attempted murder case, and this was a garden variety robbery case, so some lesser amount of time would have been more reasonable, yes.
Okay. All right. I wanna thank you for your practice here today as a not an admitted attorney. You did very, very well, and you have much to be proud of. And as counsel, you always do well. Have a great afternoon. Binmer versus Binmer. Okay, you may proceed.
I request to order my own residence at 207 East 57, where I live and where I raise my children, to be solely and exclusively mine, free from any debts or obligations, both now and forever. This property in New York is my only home. It has been where I work full-time to raise my children. After 23
Well, you came and moved into this apartment during your children's high school years when they attended one of the independent schools in Manhattan, correct?
Middle school.
Okay, and so that was the reason why you lived in that particular apartment during that period of time, correct?
That is the reason why we bought apartments for me to
Okay,
raise
but this was an apartment held by both you and your ex-husband?
Yes.
Okay, so, and he has been paying for all of the charges for many, many years during that period of time, correct?
Exactly.
Okay, and so your argument is that you should receive this apartment in total as a part of equitable distribution?
Yes, that's exactly what I'm saying. I've been a full-time mother for 22 years of our marriage.
But your children are now in Sweden in college, correct?
Correct.
And you have a master's in business administration, am I right?
You're right.
So that there is no reason now, since your children are no longer at home being cared for by you, right, to seek gainful employment.
To seek an employment. I've been pro se since 2017.
You have been what?
Pro se.
No, to seek a job, to get
A
a
job.
There's no impediment for you to get a job, not to
I
get
am
an
looking for a job. I am looking for a job, but for me, this job, to be a lawyer, actually not being a lawyer, it's a very hard job.
Okay, you can continue.
I have no other property. This property was purchased as a home for me to raise my...
I thought that there was something in the record that you stated that you had assets in the amount of $1.something million.
That is not correct. That's opposition statement.
Was it?
I'm sorry. Don't you have a place to live in Moscow and your husband
I do
got
have
friends?
a place in Moscow. I never live there, but we do have...
Well, you do have a place there, correct?
We do have place in Moscow, yes.
And you were with your children in Sweden, right?
Say it again?
You were with your children in Sweden?
I am with my...
You were?
Never.
You
Here
don't
were
spend a
they-
lot of time in Sweden with your children?
Never. I'm not. I don't have even.
Didn't you testify from Sweden, ma'am?
I testified on my visit from Sweden. I'm not allowed even to live in Sweden. I'm a Russian passport holder. I'm a lawful resident of the United States. I'm not allowed to live in Sweden.
But you do visit Sweden and stay with your children, correct?
Say it again.
Do you visit Sweden to visit your children and stay with them?
I can. Now I cannot. Now
But then you did, correct, ma'am? And you testified at this trial from Sweden, correct?
occasionally, not entirely. No.
So the record below, you had an 18-day hearing before a referee, you recall?
Correct.
And during the course of that hearing, the referee had an opportunity to hear what your ex-husband had to say and to hear what you had to say. Do you understand that? And the record also shows that through many of the questions posed to you, you pleaded the Fifth Amendment, that you didn't want to testify to many of the questions. You know that as an appeals court, we can't really substitute our judgment for the credibility determinations of the referee. Do you understand that?
The position is a formally internationally recognized huge real estate developer. He concealed our family funds.
So I found it. I found it. I'm sorry to interrupt, but I did find it. You testified that you possessed approximately $1.1 million in liquid assets in your name and jointly with your children. That was your testimony at the hearing.
That's not correct.
So that's what you said.
Yeah, that's what testimony. That's what you said.
You said.
I never said that.
You didn't take the fifth on that one. You said it was 1.1 million. No? That's what the transcript says. Okay.
That's not correct.
But in any event, equitable distribution gave the house in France to your ex-husband, gave you the house in Moscow, and here they determined that this apartment should be sold and the net proceeds divided equally in terms of that. And
I submitted,
how do you challenge that?
I submitted appraisal of Moscow apartment, and it was the referee or the judge appraised it double. And the house in France, I submitted evidence that it was actually on sale for $2.3 million. Meanwhile, the opposition appraisal was 1.2 or something.
And the New York apartment is approximately $2 million as well.
Approximately.
Isn't it listed for about $2 million?
Approximately. Besides the fact that the opposition didn't comply with judge order, he didn't disclose the entire family assets, and on page.
Okay, why don't you look through the record, because your time is up and you can tell me when you come back, okay?
Good afternoon or evening. May it please the court. We're at evening now. May it please the court. My name is Heidi Talentire of Kraus, Shackness, Talentire, and Masseri, and I represent the respondent. So there seems to be a little bit of confusion because there was an equitable distribution trial for all those days that you talked about. She took the fifth on every single question I asked her for 2 days, including things like what language do you speak in when you speak to your husband. However, that's not the order that she's appealed. The order that she's appealed that's in front of you right now is a pendente lite order that has been superseded by this court issuing a final decision after trial. The order that is in front of you right now, as we sit here today, is the September 27, 2022 order, which is a result of a pendente lite motion during the trial, because the trial took several years to complete, in part because of COVID. It was remote. My client was in Europe. The appellant was in Europe. I was in New York. And so the referee was hearing that. On behalf of respondent, plaintiff respondent, I made a motion with respect to the pendente lite issues, which included a request to sell the residence. The appellant cross-moved with a request to sell or rent the residence. That was to sell or rent the New York City residence. She cross-moved for that. She never amended that cross-motion. She never withdrew that cross-motion. That cross-motion is part of the reason on a pendente lite basis, which is the motion we're here on and the decision we're here on, that cross-motion requesting to sell or rent the New York City apartment is part of the reasoning in the decision of Justice O'Neill Levy, but also in the report of Referee Shamus on the pendente lite issues as to why it was appropriate on a pendente lite basis to sell the apartment, because it's on consent. We then finished the trial, and a few months after the referee report came out on the pendente lite motion, the decision, or the report, I should say, came out for the final distribution and equitable distribution for this case. That has not been appealed. In fact, that is part of the current lower court being converted into the judgment of divorce, incorporated into that, and we're waiting for that judgment of divorce. We have on Friday, in front of now Judge James, because Justice O'Neill Levy obviously is no longer at the lower court, but in front of Judge James, a request to expedite the judgment of divorce. The appellant has the right to appeal that, but at a minimum, it is a moot issue because there is a decision that supersedes it that is, in fact, the equitable distribution after trial, in addition to the fact that on a pendente lite basis, the appellant is requesting that this court overturn relief she sought.
Right, that's why you say she's not an aggrieved party, and therefore she should not be able to bring this act.
That's correct, Your Honor. That is correct. If there are no further questions, I rest on my brief. Thank you.
You may proceed. You have a minute.
Judge issued an order for me to pay wealthy opposition attorney fees and awarded him largest property in France, and she awarded him to sell property I live in. The opposition never disclosed family funds, and the page 627, the last paragraph, it's specifically written that a UniCredit bank account where he receives his salary. It is my understanding that New York case law can award the entire assets for non-disclosure of family funds. So that's my argument.
Thank you so much.
Thank you.
Thank you.
Minholz versus Columbia University.
I just give you my proposed materials, because I never did. Thanks. Thank you. Good evening, Your Honors. May it please the court. My name is Nicole Rosillo. I'm here on behalf of the respondent. We ask that this court affirm the lower court's opinion that the plaintiff appellant was not performing any work that was incidental or necessary to demolition. The lower court dismissed any and all plaintiff's claims sounding in labor law on this basis. The New York Industrial Code defines demolition work as work that's incidental or associated with the total or partial dismantling of a raising of a building or a structure or other structure, including the removing or dismantling of machinery or equipment. In this specific case, the plaintiff was not removing any machinery or equipment that was associated with any type of construction.
There's nothing in this record that suggests that the plaintiff, when moving the computer rack, was linked to actual construction or demolition work, correct?
That's correct.
Even though the space was intended to be demolished at some point in the future, at the time he was moving the rack, there was no construction or demolition being done. Hence, there's no trigger of any kind of labor law claim.
That is correct, Your Honor. If there's no further questions, I can just rest on my brief.
Thank you.
Thank you, everyone.
Saatchi versus Elk Manhasset. Last but not least.
Good afternoon. I think it's still the afternoon.
The debate of the day, right?
Yeah. Patrick Lawless for the appellant. I'd like to start off with the issue of indemnification. Not only was Elk entitled to indemnification, and the court should have granted indemnification, but the court,
So let's look at the indemnification clause.
excuse me?
Under the indemnification clause, Elk is to be indemnified for what?
It's to be indemnified for any acts arising out of the negligence or omissions of Anchor. That's what it says.
Past, present, or future?
Yeah. Well,
Your reaction hits the nail right on the head.
but it says till the fullest extent of the law. There's nothing wrong with
So
that.
that fullest extent of the law somehow relieves or makes up for the fact that we're talking about past, present, and future?
Is there a severance clause in this indemnification provision?
No, I don't believe so.
So then, if that language that we hesitated on is problematic because it's ambiguous, too broad, perhaps other adjectives, but let's stick with those two. How does that impact, since there is no severance clause in this provision, can we save this provision if we find that those terms render it unenforceable as too vague and overbroad?
I think the savings language till the fullest extent of the law actually does save it.
But not only, but when you say past, present, or future, what you mean is, after all, Anchor was doing stucco work on this property for you, right?
Correct.
So there's a period of time in which the contract is in effect. Then they leave the job, let's say stucco falls off of the building and hits someone on the head. So under this provision, this is the job Anchor did. Anchor is responsible under this provision to indemnify you because it's part of this job and it happened in the future.
But it has to be due to its negligence too. It specifically says arising out of the negligence.
Future doesn't mean another job. It means a future liability that's imposed upon you from this job.
Correct.
And there's no ambiguity about that. That sentence clearly relates to something which emerges from this job.
Correct.
Does it say that? From this job? Because I didn't see that in the clause, which is my concern, right? Because it cannot possibly mean that I do stucco in 1990 and in 2025, some stucco falls off this building and you can still come back after me who
But
did
it's-
the stucco 35 years ago?
It's specific to this work. It was done in.
Answer my question, because the scenario I've given you is for this work. So he's doing the stucco on the facade, right? Let's say he does that stucco in 2020. Let's say 2040, some stucco falls off and hits somebody on the head. Under this clause, if the building is sued, they can still go after
If that,
the
if,
contractor for stucco put on the building in 2020, under this clause?
if it arose out of the negligence, if it was improperly done.
And it's within the statute of limitations.
And it's within, yes, correct.
And it's clearly relating to this job because it's part of the contract for this job. I mean, this is the last page of the proposal, the contract agreement, which appears at page 221 of the record, and this is part of that contract.
Well, the only thing is that it says, or breach of contract in connection with the operations of Anchor. So, is that just limited to this contract? It just says in connection with the operations of Anchor.
It's clearly, if you look at the entire agreement between Elk and Anchor, it's clear it's referencing to this job. And It has to do with Anchor's operation in terms of the work that they performed at this particular job and this particular site.
In the record, they talk about how this particular subcontractor had work in various locations. So does this job mean this site? Or all of the locations he happened to be working on at this time? What does that mean?
No, it's this site. It's part of the contract dealing with the work performed at this site. So it would apply to this site.
All right. You'll have time on rebuttal. Who's next?
Good afternoon. May it please the court, Michael Cassell for the plaintiff's respondents. As we set forth in our brief, the court should affirm the Supreme Court's decision granting summary judgment under 241 and 241-6 to my clients who were injured. As the court found, the ladder jack scaffold failed, which is a textbook violation.
If we affirm the 240, do we need the 241-6 holding?
You've given me, and the language is in prior decision, it's academic. I do not need a 241-6. I do not need the 200, the 240, just very quickly.
Well, the 200 you abandoned, right? Because there was no response in the papers, so.
There's no response.
What's your
Abandoned.
position regarding their recalcitrant worker defense? In other words, that the proximate cause of this fall was the plaintiff's failure to use the lines and harnesses arguably available.
Well, the harnesses for recalcitrant workers, the court is aware, the harnesses have to be at the work site. Ahmed testified when he left that morning, he knew the workers didn't have the harnesses on. But most importantly, and I see this in a lot of cases, Elk's defense is basically, we're not liable because we tasked the plaintiffs, the workers, with building the adequate safety device. And I submit that would turn the entire labor law on its head. Because then if I'm a labor law defendant, I'm now incentivized to never provide an employee with a safe device. I simply say, here's the wood, here's the nails, you build the ladder. And if you build it wrong, I'm not liable. The labor law is exactly the opposite.
Well, isn't one of the things you raised in terms of 241 that the fact that there was no place to tie you up to? But does Dr. Angela Levitan create an issue of fact by stating that the parapet wall would have been an appropriate place to tie off to?
It's not an issue of fact, because even if it is an appropriate place to tie off, there was no evidence as far as recalcitrant worker that the harnesses were readily available, and my clients knowingly decided not to use it. And as far as the sole proximate cause, if there's any labor law violation, my clients cannot be the sole proximate cause. And basically what they're claiming is my clients were negligent in failing to properly construct their adequate safety device. That's the labor law requires the exact opposite. His clients required to provide the device, not simply leave the site. The guy, Mr. Ahmed, wasn't even there, was not on the site, left the site, said, you guys construct the device. Oh, you did it wrong, we're not liable.
And his EBT does not confirm that those materials were actually there. He said, I don't recall.
I don't recall if they may have been in a pile somewhere. Thank you. Any other questions?
Thank you.
I don't know if I should say good afternoon or good evening. Judges of the court, thank you for hearing me. I'd like to discuss the absence of a grave injury. The defendant, respondent, Elk, spoke of the Rusinski case, and that once I had come forward with proof that there was an absence of a grave injury, that if there is proof creating a question of fact, that my cause of action is defeated. However, with regard to the Louima plaintiff, there was absolutely nothing raised in the appellant's papers whatsoever with regard to Louima having sustained a grave injury. In fact, in something that really should have a flag hung for it, Jason Brown testified that from a from a neuropsychological perspective, Louima could return to work as of December 20th, 2021. It's in the record at pages 1647 through 1657. All of the experts in this case were in agreement, expert opinions, all in evidentiary form, that Louima had not sustained a grave injury and that there was nothing from a neuropsychological perspective whatsoever that was keeping him from working. And in addition to the 3 experts that were retained by the appellant Elk, that being a neurologist, Renee Hildebrand, a neuropsychologist, Richard D. Benedetto, and a vocational expert, Mark Ramnouth, they all said that he could return to work. There was also a workers' compensation examination by a Dr. Bienenfeld in 2021. He found a mild adjustment disorder, and in 2022, no psychiatric disability. There was another workers' compensation exam on August 3rd, 2021 by a Dr. Agrawal. He found that there was no evidence of a post-concussion syndrome and that the plaintiff could return to work without any restriction. Also in accord were Anchor's experts, Dr. Barbara Baer and Joseph Pesolano. Now, with regard to Lamache, the appellant has set forth 2 pieces or 2 items of evidentiary proof, which they claim is enough to defeat the motion. First off is an uncertified, not affirmed report from Dr. Brown from October 12th, 2021, where he did not state that there was a permanent impairment. He didn't check it off on the form. And he also did not say that in any way, shape, or form at that time that Lamache was completely and permanently, totally disabled. Also, if we look at Alalima, you can say that if he was making improvement and he was not completely and totally disabled from employment, that it fits within the statute. Also, Moises Ortiz, ruling in this court, said that a temporary total disability is not a grave injury. And the testimony of Eric Housknecht, the other one piece of evidence that the appellant relies on, from December 22nd, 2020, was that there was a temporary, total, partial disability. He never testified back in 2021 that there was a complete, permanent unemployability in any capacity. That's at the record at pages 2148 through 2150. In fact, Dr. Housknecht, in inimitable form, said, "I told you 4 times already. This is a temporary, total disability. There's nothing on this record whatsoever to say that Lamache sustained a complete and total disability."
Ms. Stark, I'm sorry to cut you off, but this is something that I'm interested in having you try to answer. Point 1, there is no dispute that Anchor did not name Elk as an additional insured under the contract breaching that agreement, correct?
That is correct, Your Honor.
Okay. And is it fair to say, and I seem to recall after reading your brief, that you don't challenge the actual provision itself in claiming that there's no basis, in countering their point that they should get contractual indemnification, do you?
No, Your Honor, I couldn't.
So in other words, you have no problem with the clause?
I don't have a defense to it, but for the fact that Mr. Ahmed testified that he didn't make the request for the insurance. Elk's office made the request for the insurance. So the only thing I can say in response was, if you bought the groceries and now you don't like the groceries, don't blame me, it's your fault. And also that it was unconscionable to expect that there would be an additional named insured under the policy because their total fee was only $10,544.63. Those were the best arguments I could make.
Thank you.
Do you need, okay,
Anything
I got the
else?
red light. Do you need anything else with regard to the
Judge
grave
Sherman,
injury?
do you have any other question? No? Okay.
Judge Friedman, you're my frequent flyer here on my grave injury cases. Any questions?
Okay. Counsel, you have time on rebuttal.
Yeah, I'd just like to go back to the indemnification agreement. There's testimony from Mr. Ahmed, and there's also testimony from Mr. Wittenstein as to this agreement, the full agreement. And they both said that all the documents, including the indemnity and insurance provision, were all part of this contract. So it's clear that the indemnification provision is referring to this job. It's all part of the same contract relating to this particular job.
So if we were to uphold this provision and make clear that the language in this provision is limited solely to the work on this job, that would be consistent with your position?
Yes, It's limited to this job. It's not to any other job. The witnesses were asked about it, and this was the contract. This
Okay.
related to this specific job, and it arises out
There's no
of...
reasonable reading of this provision that it relates to any other job.
No. And it's the testimony. The only objection or the only argument that was made by Anchor, which was completely insufficient to warrant the dismissal, but the only arguments that they made that it wasn't authenticated, which is belied by the record, that it was somehow unconscionable, which the majority of the language is completely standard in any indemnification agreement, and that...
The fact that it's I'm sorry, the fact that it may be a bad deal doesn't make it unconscionable.
Doesn't make it unconscionable. And with respect to the negligence question, no one opposed Elk's motion to dismiss 200 and common law negligence. Nobody opposed that below, and there's no basis to find it negligent. The Anchor makes an
What
argument...
you're saying is that there's no issue as to Elk's negligence.
No, there's none.
Okay.
Not at all.
We got that. All right, thank you.
You too, thank you.
Have a good night. Thanks.